Hey, good evening. Today we
Hello.
have special guest again, Nadine, back by popular demand. Thank you so much for being here. Really
Thank you for
appreciate
having
it.
me again.
Yeah. Do you want to introduce yourself to some people who are probably wondering who's this
Yeah,
person?
going, who is this person?
Yeah.
So, yes, my name is Nadine. I have been a subscriber of Judy's AA Legal Focus channel since 2022, I think, when
Oh,
I first discovered the Dan Markel case.
mhm.
And I live in Coral Springs, Florida, born and raised here, and I am a true crime. I wouldn't call myself a true crime junkie, but maybe others would. I don't see
Well,
myself that way, but I think other people do.
yeah, it's pretty impressive. We were talking about different cases, and you jumped in with these details I didn't even know about Mike
Mike
Williams's
Williams,
case and
yeah,
other
yeah.
cases.
Mhm.
So, do you watch court TV all the time or
Not all the
other
time, only
channels?
for the cases I'm following, right?
Mhm.
Where I'm interested in something and then I want to hear what people are saying and if there's really any new news, because sometimes they're just churning and it's speculation and they're trying to make content and you're not really getting anything new. But so I'm not watching it all the time, but when there's something I'm specifically interested in, I do watch. I like Vinny Politan,
Mhm.
and Julia Janae.
Mhm.
Yeah,
Yeah.
so I watched that.
Did you know I met her at the airport in
Oh,
Tallahassee? So I took a picture with her and talked to her for a while because we both just happened to be there in this lounge towards the
yeah,
front of the airport and stuff. So
yeah.
that was pretty cool to see her up close. Like she's actually pretty short, like I am, like a pretty small person.
Mhm.
But
She was at Charlie's trial. I don't know if she was at any of the prior trials, but I
yeah, I
know
don't
she was
think
at
so.
Charlie's and then she was at Donna's.
Mhm. Yeah,
Mhm.
you could see her too. So that's cool. Well, so we're shifting gears today a little bit to
Mhm.
cover the Karen Reed civil case. And this, I feel pretty interested in, uh, sorry, because this is kind of the practice area that I've specialized in, which is civil litigation.
Mhm.
So I've handled probably, I don't know, more than half a dozen cases which involve similar civil claims and defamation, things that had to do with wrongful death. So,
Right.
of course, back when I won a jury trial in this type of case, my voice was much better. So, anyway, but I was like, cool, I should cover this because so many of the law tubers and non law tubers are covering this
Yes.
civil case too. And I know Karen Reed is very polarizing.
Yeah.
So, I mean, I just have to say, I'm not going to come out with an opinion because I know I haven't done in-depth
Enough research.
research.
Yeah.
Yeah, yeah. Whereas with the, Adelson case, yes, we've done our research. We
Yeah.
believe Wendy had something to do with it. So that I feel pretty confident giving opinions on.
Yeah.
So yeah. What
I would
about you?
say I did not follow the Karen Reed case as closely as, of course, the Dan Markel case, for
Mhm,
example. But with her retrial, I did pay attention to that and a lot of the testimony. Um, and I think what I come away with, I'm comfortable saying what I think. Don't come for me, people.
mhm,
But I believe we his injuries weren't consistent with being hit by her car, her SUV, in my
mhm,
opinion. Um, and I think that the investigation was DOA when they didn't search the house. I just think they didn't. He's found dead on the front yard, in the front yard, and anybody else's house, I'm sure, would be searched if a dead body is found on your front yard,
mhm,
right?
mhm.
So on your lawn. So the fact that they didn't search the house, in my opinion, DOA. That's a big house of reasonable doubt. And there is no eyewitness that says, yeah, I saw her hit him, or a video of her hitting him. There's no evidence of it, and his injuries to me are not consistent with that. So I think they wasted time retrying her. And I think it blew up like this because it seems to be an indictment of the local police.
Mhm.
Like it
Yeah.
gave people a platform to
Mhm.
air their grievances about the corruption and whatnot that they feel this police department has. And this case just allowed people to bring it out.
Mhm.
So I think that's contributed to it, and it's just become media fodder. Now, to keep it in perspective, nobody in my life has heard of Karen Reed or this case
Oh.
with John O'Keefe.
Uh-huh.
So it is popular among true crimers, the true crime community.
Definitely.
But
Yes.
the people want to compare it to OJ, and it's like, no,
Nah.
it's not a pop culture thing.
Yeah, there's no
Um,
celebrity involved.
Right, and it hasn't risen to that level. It's not even at a Scott Peterson level. Because again, I could ask a friend or a cousin, "Hey, the Karen Reed, who? What?" Like they've not heard of it. So we need to keep things in perspective. I think it is as popular as it is, and she does have the support that she has. I think she's raised a lot of money herself, kind of like Luigi Mangione,
Mhm.
from the public because of this police department. People are very upset with this police department. It's corrupt.
Yes.
And also, them trying to kind of make a dollar out of 15 cents with this case. It's like they don't have the evidence to prove uh, that she hit him. And yet they moved forward trying to squeeze a square peg into a round hole
Mm.
to convict her.
So,
That's my opinion.
yeah, yeah. No, I appreciate it because I know how detailed you get in general with different cases we just happened to
But this
talk
one,
about.
I'm not,
Yeah.
I'm interested in seeing what she's saying in her complaint, but I didn't even know who she was suing because I stopped following it when she was acquitted.
Mhm.
I haven't been paying attention to all the other news. So I just saw when you sent me the PDF who she's suing.
Mhm.
But I had heard, of course, they've been having news on her ever since she was acquitted. There's still something to talk about.
Yeah. Yeah. I
Mhm.
mean, I think first of all, people are interested because she kind of looks good. So, when you have people who look
Fit a
nice,
certain mold. Yeah.
yeah, yeah, with that kind of blondish hair and she's thin and, sort of pretty. I mean, I don't think she's totally hot, but she was hot enough for these guys to be sort of all falling over her and stuff. Um,
I don't know. If you listened to the recordings in the trial, I don't have such a great impression of Karen Reed. And again, that's
mhm,
my opinion, and I'm
mhm.
entitled to it. Don't come for me, Karen Reed fans. I don't have anything against her, but in hearing some of those voicemails and hearing some of the things she was saying, I don't, I mean, I know she was probably drunk or whatever, but it just didn't give a good impression of her. She
Uh-huh.
also gave a number of interviews, at least a couple of interviews, that I think were mistakes. She shouldn't have done it to talk
Yeah,
about her case.
yeah, usually not a good idea
Not
if
a
you're
good idea. I'm sure her lawyers told her
potentially,
not to do it.
yeah, you're a potential
Um,
defendant.
because in those interviews, at least in one of them, again, I'm not as familiar with the details of this case. I'm a little bit more high level on what happened, but she speculated that she thought she might have hit him
Mm.
in the interview, the sit down interview.
Oh,
So it's like, she's lucky that they just didn't have any evidence, that the case was so weak and had so many big areas of doubt.
yeah, and a bunch of like crazy people that seemed like a bunch of weird, lying, filthy people.
Yes. Oh my
It's
gosh.
so
Okay.
despicable.
The McCabe's and the Alberts. So I wasn't too sure what was going on with them during the trial because, again, I didn't pay attention to, I wasn't watching that closely. But after Karen was acquitted, the four of them sat down and gave an interview, at least one interview that I saw,
Oh,
a morning show or something. And I just came away with, I don't trust these people. Something is off. I'm not saying that they had something to do with John O'Keefe's death. I don't know, but there's something off about them. They're hiding. Something is being hidden.
Mhm.
Something's off with those people. That came across to me when I watched that interview. I don't know what
Mhm.
they're hiding. I don't know what's going on, but something's not right.
Mhm.
So there's that. And I just feel like that house should have been searched.
Mhm.
I can't
Definitely.
imagine, somebody finding a dead body in my lawn, on my lawn, and not coming and wanting to search my house.
Exactly. Exactly. And I mean, once again, I am certainly not an expert, but didn't they all stay inside the house when the police finally showed up? Like nobody came out to see what's going on.
I'm not sure if nobody came out, but I know, like, who was it that lived at the house? Was it the Alberts? I don't
Yes,
remember.
I
But
think so.
yeah, the one guy who said he was in his bed in the interview, he was trying to explain why he didn't come out right away or something. Like, Jen McCabe came into their bedroom and told them that John was on the lawn or something like that. And he was saying, oh, like he needed to get dressed or he had been sleeping, or, he was trying to explain why he didn't come out right away. I don't know. But something was just off with the four of them. That's all I know.
Mhm.
The
Mhm.
energy was
Yeah.
off.
Thank you guys for this because, it sort of takes a village to make sure we get the facts straight because even in Dan Markel's case, there are so many people chattering. Sometimes you don't
So much
know which
misinformation.
commenters are
Hmm.
legit and really know the facts versus some commenters that are deliberately coming up with stupid ideas just to get
Exactly.
attention
Not just
or
commenters, but YouTubers. I've noticed some YouTubers, they're just hopping on the bandwagon and their presentation is full of misinformation and incorrect little details. Yeah, it's annoying. And some of them are
yeah.
pretty popular because the videos are well produced, with AI and all that stuff, but yet they're giving misinformation.
Mhm. Yeah, not I mean, I think even Loophole Lawyer would agree with that because it became like a running joke that every time he put up a video about Dan Markel's case,
Mhm.
then I would jump in and say, "Hey, this is wrong. This is
Right.
wrong. This wasn't really true. Let me, but of course, most people don't read the fine print details.
Exactly.
So, yeah, so always remember it's just YouTube. I mean, I'm no expert in this case, but since I have handled plenty of civil litigation cases,
Mhm.
I kind of felt like, hey, this is something I'd like to pivot and cover to some extent, especially because we're still waiting for Wendy's arrest.
Yes.
So, what else are we going to do? Right.
Yeah. So
So,
people are
yeah.
saying no one came out of the house until John was taken away to the hospital. Well, that's
Oh,
very sus.
oh, yeah. Yeah. I
That's
recall
really
hearing
sus.
that. Yeah.
I didn't know. I don't know all these little fine details about it. I just know the conspiracy theories went crazy. So at some point, you just kind of back off because it's like you don't know what is real and what people are just fabricating for attention. But yeah, if they didn't come out of the house after hearing he was on the lawn, who wouldn't come running out to see what's going on?
Mhm. Exactly.
So,
Yeah. Okay. Well, thank you guys for all your input and
yeah, thank you.
information and stuff. Okay. This person says no one went into the
To the
house.
house.
Okay.
Brian nor Nicole nor Brian Jr. came outside. Well, who did come outside to see what was going on?
No one came out till the cops sent someone in to wake them.
Yeah, they said Jen McCabe came into their bedroom and told them early
Hmm.
in the morning.
Hmm. Who was the one that Googled house
Jen
long
McCabe.
to die in the snow?
Yeah, that's become
Okay.
a whole thing.
Yeah.
HOS, how long to do this? How long? They've even been using it in the Adelson stuff.
Yeah, yeah, it's become a joke. But
Yeah.
what was her relation to the victim? Was she friends with him?
She was friends with Karen Reed.
Uh-huh. Okay.
And she's related to the Alberts, like the sister of the Albert's wife, the his I forget their names.
Okay.
But she's
Yeah.
also a friend of Karen Reed because she was driving around with Karen Reed looking for John that morning.
Mhm. Okay.
Yeah.
Yeah, it's Brian and Nicole Albert,
Right. Brian,
and
Albert,
Chris
and
is the
Nicole.
son, right?
So
Isn't Chris the son?
that I don't know. I'm not sure about
Okay,
the son.
because oh no, Chris is the brother. Colin is the son, the one
I
who
don't
had a
know.
propensity for fighting and stuff. Okay, well, before we dig ourselves into a hole with people saying, "Hey, let me be on your show. I know a lot more than you all."
Exactly.
You guys out there, thank you so much for watching, because it's hard to come up with new ideas when we're still waiting for Wendy to get arrested someday. So if you really know this case, if you'd
Oh, yeah,
like
there
to
are
be
people
on,
who really know the
yeah,
Karen Reed case.
let
Yeah.
me know your email. So anyone who would like to be the expert, and you like speaking, so
You can
and you
get
don't
Turtle Boy. Get Turtle Boy.
there's something a little unlikable about Turtle Boy, so
I
I
don't
don't
know. I haven't
think
watched
so.
him. I just became aware of him a little bit with Loophole Lawyers videos
Yeah.
and the beef he got into with Joel at STS.
Yeah, I thought that was mean and petty. Yeah.
Yeah, they were both a little petty, but Turtle Boy was saying Joel was taking his comments out of context and misrepresenting what he was saying. I don't know. But yeah, I'm not sure about Turtle Boy's involvement with the Karen Reed case. I know people say he's been instrumental. I think a lot of people think he's been really instrumental in Karen Reed being vindicated.
Hmm. Yeah, he's
So,
certainly done a ton,
yeah,
trying to rally to her defense. But it
support. Yeah,
sounds didn't she seem like she was mad at him though, like after a while? I
I don't
I
know
don't know.
those
I've
details.
just been
Yeah,
reading a little bit.
I
Yeah,
don't know.
okay. Well, thank you guys. Oh, okay. So there's a 10-year-old missing. Oh, yes. Yeah. I've heard about that case too. And wasn't it in Tallahassee? Yeah,
Went
where
missing in
there was
June,
a
not
little
reported
girl.
until October. Oh gosh,
Yeah, yeah,
another
I
Casey
think I heard
Anthony.
that. Yeah. Okay, so Colin is nice, but he has an online persona. Okay, his persona seems kind of like a, kind of mean teenage boy persona. So I don't know. I mean, I haven't watched a ton of him, but sometimes you just don't have time to watch every single person on YouTube covering different true crime cases. Yeah,
Yeah,
people's fantasies are running wild. People are so out of touch. Yeah, well, that's the thing. It's like people can get so addicted to a case that that's all they want to obsess on, and I admit that's me with the Dan Markel case.
yeah, but
So
not to the point of becoming irrational, becoming um, you know,
like a
offensive to
total
other
nut.
people. And yeah, it's like, keep your head about you. You can become invested. We're invested in the Dan Markel Justice for Dan. But we haven't become idiots because of it. you know?
Yeah, let's hope not. Yeah. Okay. Well, do you want to get into doing the reading? And if
Yes,
you need a break, just let me know, because
yes.
the whole thing
Let me
is
get my
about
water.
46 pages. But of course, you don't have to read all the legal
Let's go.
citations and
It might
headers
go
and all that.
quickly. Yeah.
Yeah. Okay, so let's dive in. Once again, huge, huge thanks to Nadine, because
My
everyone loves
pleasure.
her voice. Yeah.
My
So,
pleasure.
yeah. Okay, so here we go. Okay.
Yeah, so she's suing Michael Proctor in his personal capacity, Sergeant Yuri Buchanan. How do you pronounce that?
Yeah, they said
Lieutenant
Buchanan.
Buchanan, Lieutenant Brian Tully, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. I thought that was very interesting that she's
Mhm.
suing the Alberts and the McCabes.
Mhm. Yeah.
Okay, complaint. Introduction. For 3.5 years, plaintiff Karen Reed was, can you make it a little bit bigger?
Sure.
A bit. Okay. For 3.5 years, plaintiff Karen Reed was wrongly accused of homicide and subjected to suspicion, arrest, two prosecutions, and public condemnation, all resulting from the gross misconduct of the Massachusetts State Police, MSP, and those working in tandem with the MSP to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe III. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those.
Do you mind reading these
Oh, the
footnotes?
footnote.
Because I think it's important.
Okay. Massachusetts State Police and Town of Canton will be added as defendants after too big. After presentment is made pursuant to this statute, GLC 2584. And footnote 2 says plaintiff intends to move to consolidate this action with the related action Estate of John O'Keefe et al. Versus Reed et al. Civil action number 2483-CV-00692, related action for discovery and trial efficiencies. So now it's a little bit, yeah. Actually, so let's start that sentence again. So it says now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who abjectly failed to ensure that justice was sought and served in the aftermath of January 29th, 2022. Number 2, Karen Reed did not kill her then boyfriend, Mr. O'Keefe. Rather, in the early morning hours of January 29th, Mr. O'Keefe was killed in defendants Brian and Nicole Albert's home at 34 Fairview Road in Canton, quote unquote, the house, in an altercation during a late night house party with other defendants, collectively the house defendants, after a night of heavy drinking. The House defendants responsible for Mr. O'Keefe's death, some of whom had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. Rather than call first responders for help, among other actions, the House defendants conducted a Google search for information about, quote, "Hoss long to die in the cold," unquote, moved Mr. O'Keefe's body outside, and placed him on the Alberts' front lawn near the road to make it look like Mr. O'Keefe was hit by a vehicle and that he died in the snow without ever coming into the house that night. Mr. O'Keefe's body remained on the Alberts' lawn until Karen Reed found him later in the morning. From the beginning, investigators from the MSP allowed the House defendants to direct the investigation away from themselves and towards Ms. Reed. The House defendants were a well-connected and close social group with strong ties to law enforcement. The Alberts are a prominent family in Canton, and the investigating police officers knew them well. The lead investigator for MSP, Michael Proctor, grew up in Canton and resides there to this day. He has been and remains close personal friends with the Albert family. House defendant Brian Albert was a longtime Boston Police Department officer, and House defendant Brian Higgins was an agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF. Number 4, adhering to the unwritten rule of, quote, protecting their own, unquote, Proctor and his MSP colleagues intentionally disregarded the obvious and compelling evidence tying the House defendants to Mr. O'Keefe's murder. Specifically, Mr. O'Keefe's injuries were consistent with a physical altercation. He had bruises and lacerations on his face and a deep gash to the back of the head, suggesting that he was punched and fell backwards, hitting his head on a rigid surface. He also had dog bite wounds and scratches on his right arm and forearm. Equally evident, Mr. O'Keefe did not have a single injury consistent with being struck by a vehicle. He did not have any broken bones or even a bruise on his legs, feet, arms, shoulders, torso, back, ribs, or anywhere below his neck that a medical examiner would otherwise expect to find on a person struck and killed by an impact from a 3-ton vehicle. And to erase any doubt, the Commonwealth's own medical examiner, the pathologist who conducted the autopsy for the Commonwealth, concluded that Mr. O'Keefe's body showed no signs of a vehicular strike. Number 5. Despite that, Proctor and others shielded the House defendants by intentionally sidestepping fundamental investigatory procedures. Propelled by the House defendants' false statements, including that Mr. O'Keefe, quote, never went into the house, unquote, Proctor reported in text messages just hours into the investigation that the House defendants weren't going to get any shit for this, quote unquote, because, quote, he's Brian Albert, a Boston cop, unquote, and that Proctor was determined to make the investigation cut and dry, quote unquote, by bringing charges against the girl, quote unquote. Indeed, Proctor made his intentions clear in writing. Karen Reed had, quote, zero chance of skating. She's fucked, unquote. This pronouncement was a mere 16 hours after Mr. O'Keefe's body was discovered on the Alberts lawn, and Proctor had not even walked into the house. Number 6, true to his promise, Proctor and his colleagues did not search the house for blood evidence resulting from the gash to the back of Mr. O'Keefe's head, or for fingerprints, or for DNA evidence. Proctor did not search the house despite the fact that Mr. O'Keefe was discovered without a winter coat, without the hat that several witnesses said he had been wearing that night, and without his left shoe. At Proctor's direction, the house was never processed by a criminalist or even photographed. No member of the MSP, including Proctor, set foot inside 34 Fairview for nearly a week. The police did not examine or take evidence from the Alberts German Shepherd that was in the house on January 29th, a dog that had a history of attacking other dogs and people. Wow, I didn't know that. 7. Neither Proctor nor any of the MSP troopers conducted physical examinations of the House defendants for evidence of involvement in the altercation, such as marks on their hands, knuckles, or face, or bruises on their bodies. They did not seize or search the House defendants' phones. They conducted only perfunctory, unrecorded conversations with Proctor's friends and acquaintances without any attempt to corroborate their stories. They permitted would-be witnesses to communicate with each other and coordinate their stories before any formal interviews. They allowed critical evidence to be manipulated in some instances and outright destroyed in others. In short, by focusing the investigation solely on Ms. Reed, as implicitly directed by the House defendants through the misrepresentations they made to police, Proctor and his colleagues disregarded and failed to obtain pertinent interviews and other critical evidence from the House defendants that cannot now be recovered or recreated. Number 8, Proctor also secretly communicated with the Alberts on his personal phone, deliberately back-channeling those communications to circumvent his state-issued device, and used his sister as a conduit. For instance, on multiple occasions, Proctor disclosed critical and confidential information about the investigation to his sister, who passed that information to her close friend Julie Albert, Brian Albert's sister-in-law. Julie Albert then passed that same information on to the rest of her family and the House defendants. Part of these communications included Julie Albert's promise to buy Proctor a quote unquote thank you gift for handling this investigation in a manner that intentionally avoided implicating the House defendants and singularly focused on Ms. Reed. Number 9. Proctor then went so far as to manufacture evidence to ensure that Ms. Reed, not his friends and fellow law enforcement officers, was blamed for Mr. O'Keefe's death. This included planting evidence at the scene on Mr. O'Keefe's clothes and on Ms. Reed's vehicle to support the false narrative that Ms. Reed hit Mr. O'Keefe with her car, even though he knew, I lost my line, even though he knew Mr. O'Keefe's injuries were inconsistent with a motor vehicle strike and consistent with a physical altercation and dog attack. Number 10. Far from conducting an objective investigation with integrity, Proctor personally sexualized and dehumanized Ms. Reed throughout the investigation. Specifically, Proctor's private communications to his high school buddies, sister, and MSP colleagues that he believed would never be discovered expose the corruption and bias at the core of MSP's entire investigation. Specifically, only hours into the investigation, in a text chain with 8 of his high school buddies, Proctor stated that Ms. Reed is a whack job cunt, quote unquote, retarded and a nutbag, and a babe with no ass. Proctor further ridiculed and derided Ms. Reed for her serious medical condition, stating that her balloon knot, quote unquote, leaked poo, quote unquote. In other private text messages to his MSP supervisors and colleagues, Proctor bragged that while conducting a search of Ms. Reed's phone, he was looking for naked pictures of Ms. Reed. Disappointed, he reported that there were, quote, no nudes so far, unquote. In an unfiltered utterance, Proctor revealed his true mindset. Hopefully she kills herself, quote unquote. 11. Indeed, Proctor's supervisors and the MSP knew about and condoned Proctor's unlawful conduct, and in some instances expressly encouraged this flagrant abuse of power. For example, on one occasion, Proctor's immediate supervisor, Yuri Buchanan, responded with a thumbs up emoji to a text calling Ms. Reed retarded. Proctor's supervisors and the MSP knew Proctor had a close relationship with the Alberts and that he made no secret of his bias against Ms. Reed, demonstrating a clear prejudice against her from the outset. Number 12. Relying on manufactured evidence, actively ignoring exculpatory evidence, and without investigating obvious signs pointing toward the House defendants, the Commonwealth secured 2 separate arrest warrants for Ms. Reed and a knowingly baseless indictment against her, and then wrongfully prosecuted her for murder twice. As alleged below, these unlawful acts not only underlie plaintiff's meritless wrongful death claim against Ms. Reed, but they also form the foundation for Ms. Reed's claims against the defendants. These acts violated Ms. Reed's state and federal constitutional rights, the Massachusetts Civil Rights Act, and well-established Massachusetts tort principles. 13. On June 18, 2025, after a 2-month trial, a jury rejected the Commonwealth's theory, in part because the overwhelming physical, scientific, and medical evidence established that Ms. Reed's vehicle did not strike Mr. O'Keefe, and that Mr. O'Keefe's injuries did not come from a vehicle strike. Although Ms. Reed was ultimately and finally acquitted of all charges related to the death of Mr. O'Keefe, Proctor was fired, and nearly every MSP officer in Proctor's chain of command was disciplined for their egregious abuses and misdeeds. The Commonwealth still has not sought or provided justice, not to the O'Keefe family, not to the community at large, and certainly not to Miss Reed. In response, the Commonwealth has offered only empty platitudes instead of solutions. The head of MSP, Colonel Jeffrey Noble, stated, quote, "The events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Under my direction as colonel, the state police has and will continue to improve in these regards." Unquote. In an interview with the Boston Herald, Noble acknowledged the systemic nature of MSP's conduct in Ms. Reed's case. Quote, "I'm eyes wide open to a culture issue that I have concerns with as it relates to Trooper Proctor." Unquote. These hollow words do nothing to right the devastating wrongs that have been visited on Ms. Reed. Colonel Noble's words confess a sickness deep in the marrow of the MSP, but offer no remedy, no medicine, no relief to someone so brutally victimized by it. 15. On Wednesday, March 19th, 2025, following the public disclosure of Proctor's illegal and unethical conduct related to the Reed investigation, the MSP's trial board found Michael Proctor guilty of a Class A violation, which included, quote, "that he was biased in his dealings with a homicide suspect and or brought otherwise himself and the Massachusetts state police into disrepute." Unquote. Number 16, Ms. Reed's life was not merely turned upside down by the MSP's and the House defendants' misconduct, it was forever changed by the defendants' transgressions and wrongdoing. The years of uncertainty and unimaginable emotional distress have left lasting scars that will never heal. At the same time, neither Mr. O'Keefe nor his family has received justice. His killer or killers still walk free. By asserting her claims against MSP, Proctor, his supervisors, the town of Canton, and the House defendants, Ms. Reed seeks, at minimum, to confront and redress these wrongs and others. More importantly, she seeks to force the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own. Part 2. Parties. 17. Plaintiff Karen Reed is an individual residing in North Dighton, Massachusetts. I hope I pronounced that right, Dighton. 18. Defendant Michael Proctor. Proctor is a former Massachusetts State Police trooper residing in Canton, Massachusetts. He's being sued in his personal capacity. Number 19, Defendant Sergeant Yuri Buchanan. Buchanan is a Massachusetts State Police trooper residing in Stoughton, Massachusetts. He is being sued in his personal capacity. Number 20, Defendant Lieutenant Brian Tully is a Massachusetts State Police trooper residing in Hingham, Massachusetts. He's being sued in his personal capacity. Number 21, Defendant Brian Albert is an individual residing in Norwood, Massachusetts. 22, Defendant Nicole Albert is an individual residing in Norwood, Massachusetts. 23, Defendant Jennifer McCabe is an individual residing in Canton, Massachusetts. 24, Defendant Matthew McCabe is an individual residing in Canton, Massachusetts. 25, Defendant Brian Higgins is an individual residing in Sandwich, Massachusetts. Part 3, Jurisdiction and Venue. This court has jurisdiction over all claims in this case pursuant to GLC 12 something 11I, and with regard to the federal claims pursuant to Resnick versus Chief of Police, 374 Massachusetts, 475 484 1978. Number 27. Venue is appropriate in this court pursuant to MGL C223. 1, because at least one party to this case, plaintiff Karen Reed, resides in Bristol County. As stated above, footnote 3, as stated above, MSP will be added as a new party by amendment once the applicable presentment period expires. So they plan to sue the police department, but there has to be like a certain amount of time
Yeah, I
that passed.
guess maybe there's some statutory requirement of what has to be done first
Right.
before they can sue the police.
Mhm.
So, okay, go ahead.
Okay.
Oh, do you need a break?
Nope, I'm good.
You sure? Okay,
Yeah.
thank you. You're amazing.
What
Wow.
page are we on?
Uh, page 9
9.
out of 46. Well, the last few pages could just be like a certificate of service and signature page. So, but we're still not even halfway through. So,
Yeah.
yeah. Okay.
Okay,
Thank
part
you.
4, facts common to all counts. Mr. O'Keefe's death, number 28. Before his death, Mr. O'Keefe and Ms. Reed were dating. Number 29. On the evening of January 28th, 2022, Mr. O'Keefe and Ms. Reed went out for the night. They first went to C.F. McCarthy's in Canton, where they had several drinks. They then went to the Waterfall Bar in Canton. Number 30. There, they met up with a group of acquaintances, including Brian Albert, his wife Nicole Albert, Brian's brother Chris Albert, and his wife Julie, Jennifer McCabe, Nicole's sister and Brian's sister in law, her husband Matthew McCabe, and Brian Higgins. The group of acquaintances had several drinks and planned to continue the party back at the Alberts' home in Canton at 34 Fairview Road, the house. House defendant Jennifer McCabe told John O'Keefe that he should come to the house. 31. The group had overlapping social relationships. At the time, Brian Albert was a Boston police officer, as was Mr. O'Keefe, though they did not know each other well. Brian Albert and Brian Higgins were close friends. Higgins was an officer with the ATF. He also was permitted to keep an office at the Canton Police Department, CPD, alongside Brian Albert's brother, Canton Police Detective Kevin Albert. Kevin Albert had a professional and social relationship with Michael Proctor. Number 32. Brian and Nicole Albert's son, Brian Albert Jr., and his friends were already at the house for Brian Jr.'s birthday. In addition, Colin Albert, Brian Albert's nephew, was present. Number 33, Ms. Reed and Mr. O'Keefe had never been to the house before January 29th, 2022. They arrived in front of the Alberts' home around 12:20 a.m. Ms. Reed was reluctant to attend the party for several reasons, including that she was unsure whether they were at the correct location and whether they were even welcome to the late night party. Mr. O'Keefe got out of Ms. Reed's SUV and indicated that he would check out the party and report back to her. Mr. O'Keefe walked toward the front door slash garage door area of the house and entered one of the two doors. A period of time passed without any word from Mr. O'Keefe. Ms. Reed, who was still hesitant to join, presumed that Mr. O'Keefe intended to stay and therefore she left to go home without him. 34. At some point after entering the house slash garage, Mr. O'Keefe was involved in a physical altercation either inside the house or garage. During that altercation, the Alberts German Shepherd attacked him, and Mr. O'Keefe sustained multiple dog bites and scratches on his right arm. He also suffered an incapacitating contrecoup wound on the back of his head. Mr. O'Keefe's head wound was caused by falling backward and striking a rigid surface. The Alberts garage contained such surfaces. By contrast, the head wound could not have been caused by a vehicle strike or falling backward onto a flat, cold lawn like the Alberts. Number 35. Because of their knowledge of criminal investigations, the Alberts, the McCabes, and Higgins, house defendants, knew that calling for medical care to help save Mr. O'Keefe's life would trigger immediate and irreversible risk of their own criminal exposure. Therefore, at least the five of them agreed on a simple plan to exonerate themselves and implicate Ms. Reed. They would tell anyone who inquired Mr. O'Keefe, quote, never entered the house, unquote, and hide evidence that he was there, including his body. Number 36. Sometime during the night, they repositioned a Ford Edge vehicle at a spot adjacent to the front lawn, which obscured the view of that area of the lawn from potential passersby. At some point further in the night, they carried or dragged Mr. O'Keefe's body to that same area in the yard, close to where one or more of them later claimed Ms. Reed dropped off Mr. O'Keefe earlier that night. The plan was devised to make it appear that Mr. O'Keefe had been struck by Ms. Reed's vehicle and then died as a result of exposure to the cold. Number 37. Mr. O'Keefe was either dead when the House defendants left him on the Alberts lawn or he died shortly thereafter. Number 38. After the physical altercation, Higgins left the house and drove to the Canton Police Department in the middle of the night. He later told investigators he had to do some quote-unquote administrative work, but then changed his story subsequently, stating that he drove to the station because he had to move cars in the parking lot due to the snowstorm. However, video from inside the station shows Higgins walking down the hallway and surreptitiously entering offices while wearing a hoodie to obscure his face. Surveillance video outside reveals Higgins transporting a large bag from one vehicle to another before driving away. Number 39. After leaving the police station, Higgins and Brian Albert continued to coordinate their stories by calling each other multiple times in the early morning hours, and ultimately spoke with each other on their cell phones at 2:22 a.m. Later, both Brian Albert and Higgins denied the existence of these phone calls, and then when confronted with their existence by a, quote, separate law enforcement agent, unquote, a non-MSP and non-CPD law enforcement agency, a, quote, separate proceeding, unquote, they coordinated the same exact lie, falsely claiming the multiple calls and answers were just, quote unquote, butt dials. However, 5 minutes after the Higgins-Albert call, Ms. McCabe performed a Google search on her phone at 2:27 a.m. Quote, Haas long to die in cold, unquote, misspelling the first word. Ms. Reed searches for Mr. O'Keefe. Number 40. Ms. Reed began the search for Mr. O'Keefe on January 29th, just before 5 a.m., when she awoke and realized he had not returned home. She phoned House defendant Jennifer McCabe, who already knew exactly what had happened to Mr. O'Keefe. Ms. McCabe insisted that Ms. Reed drive to McCabe's house rather than driving to 34 Fairview Road, which Reed did. The two of them were then joined by Kerry Roberts, and the three of them left the McCabe residence. However, rather than go to 34 Fairview, oddly, Ms. McCabe directed them to go back to Mr. O'Keefe's home, where Ms. Reed had just come from. After the three of them finally drove to 34 Fairview, the illogical McCabe-directed route to 34 Fairview was intentional. It allowed the House defendants more time to finish creating the scene and hiding evidence before Mr. O'Keefe's body was discovered on the Alberts lawn and first responders arrived. Number 41. As they approached the house with Ms. Roberts driving, Ms. Reed saw Mr. O'Keefe almost immediately. She screamed for Ms. Roberts to stop the vehicle and jumped from the moving car to run to Mr. O'Keefe. She began rendering aid, including CPR. As the House defendants had planned, Mr. O'Keefe's body was, quote-unquote, discovered in front of the Alberts house, near a flagpole and fire hydrant on the left side of the Alberts property, as seen from the roadside. The Ford Edge, which had been parked in a position to obscure Mr. O'Keefe's body in the middle of the night, had been moved. Number 42. While Ms. Roberts joined Ms. Reed with administering CPR, Ms. McCabe did not help or even approach Mr. O'Keefe. Rather, she sat in the cab of the vehicle, called 911, and reported that, quote, there's a man passed out in the snow, unquote. Despite knowing that her brother-in-law, Brian Albert, a police officer and first responder, was just feet away inside the house, Ms. McCabe never went into the house or requested that Albert come down to help Mr. O'Keefe. Rather, as Mr. O'Keefe lay dying in the snow, Ms. McCabe stood and watched with no fear, urgency or even concern for her family members residing mere feet away. Number 43. The CPD were the first on the scene shortly after 6 a.m. At the time, there was no evidence that Mr. O'Keefe had been hit by a vehicle. In fact, the evidence suggested just the opposite. His body did not show signs of trauma commonly associated with being struck by a car. There were no bone fractures or trauma to his lower body, his torso, or any other part of his body as investigators would expect from a vehicle strike. Rather, Mr. O'Keefe's injuries were consistent with being physically assaulted to the face and head and attacked by a dog. For good reason, the ranking CPD officer on the scene, Sergeant Michael Lenk, opined on a telephone call captured on a dash cam that Mr. O'Keefe looked like he had been in a fight. Number 44. Moreover, the initial search conducted by Canton police officers revealed that there was no vehicle debris on the lawn at 34 Fairview, let alone any debris at or near Mr. O'Keefe's body. Not a single piece of taillight material was discovered on the lawn that morning or in the roadway, notwithstanding multiple searches and the use of a leaf blower to remove snow. Number 45. Tellingly, despite the commotion outside, including more than a dozen first responders, 3 police cruisers, 2 ambulances, a ladder fire engine, all with their emergency lights flashing, and at least 2 civilian vehicles, plus Ms. Reed's screams upon finding Mr. O'Keefe's body. No one from the Alberts house, including police officer Brian Albert, ever went outside to see what was happening, let alone help. They wanted to avoid scrutiny from the police investigators. Number 46. Sergeant Lank was a longtime friend of the Alberts and the first law enforcement officer to enter the house. He spoke to the Alberts and the McCabe's. Pursuant to their plan, the Alberts and the McCabe's told Sergeant Lank that Mr. O'Keefe had never entered the Alberts' house the night before. The Alberts and McCabe's statements were false. Mr. O'Keefe arrived at and entered the house or garage where he was assaulted, attacked by the Alberts dog, and suffered a fatal injury to the back of his head. Number 47. Despite Mr. O'Keefe's injuries being wholly inconsistent with the story the House defendants were now telling, neither Sergeant Lank nor any other member of the CPD searched the house to determine whether the occupants or anyone else were involved in Mr. O'Keefe's death. Nor did they request to search the occupants' cell phones, observe their bodies for evidence of a fight, or even secure the scene where Mr. O'Keefe's body was found. They failed to do so because of bias born of friendship and loyalty in favor of the Alberts and McCabe's. Number 48. After Sergeant Lank returned to the CPD, 3 hours after the discovery of Mr. O'Keefe's body, and more than 2 hours after being interviewed at the Alberts' home that morning, Ms. McCabe called Sergeant Lank to report that she, quote unquote, recalled additional information. As part of the plan to implicate Ms. Reed and remove suspicion from the House defendants, she falsely told Sergeant Lank that Ms. Reed told her twice that morning, "I hope I didn't hit him." Quote unquote, "I hope I didn't hit him." More than a year later, at a separate proceeding, Ms. McCabe changed her story on this topic yet again. In furtherance of the House defendants' plan, McCabe then falsely reported that Ms. Reed outright confessed to hitting Mr. O'Keefe right after she first found him in the snow. Proctor leads MSP investigation despite conflicts. Number 49. Michael Proctor was assigned as the case officer and had primary responsibility for the MSP investigation of Mr. O'Keefe's death. Sergeant Yuri Buchanan was Proctor's direct supervisor. Lieutenant Brian Tully was the supervisory officer at the Norfolk County State Police Detective Unit and thus supervised both Buchanan and Proctor. In their roles, Buchanan and Tully both knew at all times exactly the extent of Proctor's misconduct in investigating Mr. O'Keefe's death as described below. Now I can take a little water break.
Okay, sure. Yeah, thank you so much. If this is too much to read, in one sitting,
No, do
then
some
we
more.
could
We can do more.
reschedule it also
Yeah.
for a different date. But I just want to say that, of course, to be objective, this is just the plaintiff's very biased view of everything. And the
Yeah.
plaintiff has the burden of proving this in a civil case. So, for example, long time ago, I was defending a small business in
Mhm.
an employment dispute, wrongful termination, where the plaintiff just had this totally exaggerated story of how she had been mistreated by this horrible company and,
Yeah.
forced to look at kitty corn. And so she was going off in her complaint. And when I read it, I was like, this is just so much BS. Just because somebody put it in a complaint
Doesn't
doesn't
make
mean
it
it's
true.
really true. But
Mhm.
you know what? I suspect the plaintiff's attorney took that complaint as soon as it got filed and took it to the local media. So they reported a totally biased story against my client. And they said, like at the very bottom of their report, they said, we tried contacting the company's attorney, but
Mhm.
did not get a response. And I was like, well, this is such BS that I think they might have just like tried calling me after the business day was over and
Yeah.
then quickly rushed to publish this in the local newspaper. This was quite a while ago when people still read newspapers. But I was
Mhm.
so pissed off when I saw that because they didn't give my client's side of the story. So, of course, we can't just take everything as truth. So
Right.
that's
They're
that's the
allegations.
caveat. I'd
Yeah.
like to try to stay objective, but this does sound totally compelling. It sounds very well written, lots of details.
Yeah, and it does make an allegation that I don't know how she will be able to prove. That they all had this conspiracy to cover this up, but how would she prove that at trial?
Well, I
Unless
think
you have
that
somebody testifying against, like,
somebody suddenly turning and,
yeah.
doing some sort of aha moment, like, "You got
Yeah.
me, I break down now, let me tell you the truth."
What
Yeah.
happened? Yeah.
Well, I mean, of course, this is the beginning stage of how they're going to eventually do tons and tons of depositions of
Right.
all the defendants and people involved in this whole case. So that's it's a positive for the plaintiff because then she and her attorneys will be able to question tons of people to get more information
They
as
might
part
all
of
just
this
plead the
whole
fifth.
process. Hmm?
They may all just plead the fifth, like Wendy in the depositions.
Yeah,
I
if it's
assert,
likely
I
to
assert, I
incriminate them.
assert.
Yeah, it could be. Or, I mean, I don't know how well off these defendants are, but I mean, if they have pensions, if they have property, real
Mhm.
estate, then there is a chance that there could be some sort of deep pockets here. And there's also a chance that their homeowners insurance, or perhaps, I'm not even sure if their employer might be implicated in this. It does sound like she's going to add the police
Yeah.
department too
Mhm.
as a defendant. So that could be another motivation, of course, because usually people file lawsuits because they want money
Right.
from the defendants.
Mhm.
So um, just to tell another story so you can rest for a minute here. So I had this one crazy defamation case about maybe 12 years ago. And it was so weird. It was like a bunch of neighbors who were all mad at each other. They were claiming that this old guy in the neighborhood was acting creepy and harassing this
Mhm.
family. So the family contacted me to defend them. And lo and behold, their homeowners insurance actually stepped up and said, we will cover this. I'm like, really? Okay, well, get your homeowners insurance to provide you with a free attorney. But
Right.
they still, they didn't really trust the insurance attorney. And, they still wanted to hire a personal attorney.
Right.
So that's how I stayed involved in this case. So there was like defamation and emotional distress and other types of claims, but ultimately the case did settle. So,
Mm,
and so did this other lawsuit that I was involved in. So that's what sometimes people just want. They just want to do the discovery and
right.
then maybe get some sort of settlement.
Right, because
Yeah.
it's going to be costly on both sides. It'll be costly
Mhm.
for them to defend themselves, and
Yeah.
it can drag on for years, civil cases.
Yeah,
So,
very. Yeah, it could drag on for like 2 years or more. Plus, there
mhm,
could be appeals. So,
mhm,
I do wonder. Maybe some people in the chat note this, but how can Karen afford all of this? I mean, I heard there was like a legal defense fund that was raised for her, but her father said recently that she lost her last couple of jobs because of this mess. But then he also said she's been traveling and spending time with her friends. So I'm like, how can she afford to do that? Is she from a rich family? So if you guys can give some info, that would be helpful.
yeah,
Um,
I just remember hearing that um, her family may have had some money, and I think she had a fairly good job. Wasn't she in finance or like a
yeah,
finance professor
Fidelity.
or something?
Mhm. Yeah,
Yeah.
she had some adjunct professor job, I think, teaching
Mm,
finance. So
yeah.
yeah, but that money could be wiped out with all these attorneys' fees. So I'm
Yeah, but
just wondering.
she's raised a lot
Mm,
from her fans, like the GoFundMe or whatever it is. I heard that she was raising like maybe enough money to pay her lawyers.
oh, okay.
And the thing that I thought was
Thank you.
interesting is her attorney, Alan Jackson, he's out of California.
Mhm. Yeah,
So it's like, how did she get a lawyer to come from California to represent her in Massachusetts?
yeah, exactly. Oh, okay. Thank you, guys. They were working for free at the end. Karen signed multiple multi-million dollar deals, like
They were
with
working for free at the end, really?
the media, maybe, or people wanting to make specials about her case or something. Okay, her
Really?
attorneys are working for free because they believe in her innocence.
Really?
She had several defense funds.
Yeah, that's
Oh,
what I heard. There, a lot
oh,
of money was donated to pay for her defense.
hmm, yeah. Okay. Well, I haven't followed the chat, but yeah, just try to keep it civil. I know this is a very hot button type of case where people are very adamant about their points of view. So
Yeah.
as long as
You
no
don't have
one's
moderators?
cursing, well, there are. Well,
Mm,
Maui and I think Angela is here. Yes,
okay.
thank you. Thank you, guys. Yeah. I mean, I would
Yeah.
say if someone's like cursing and making threats,
Yeah.
then
Block them.
that does warrant it. But otherwise, healthy debate could be good, you know?
Oh, of
Okay.
course. I mean, and different points of view, but I really think they made a mistake in prosecuting her based
Mm,
on how the investigation was messed up, based on the fact that you have, making a not so parallel OJ reference, but Proctor was basically the Mark Furman of this case,
mhm,
right? If anybody knows anything about the OJ case, Mark Furman was the lead detective on that case, and Proctor's the lead one here. And
mhm.
I mean, the things he was saying, I mean, you can't trust anything he did. you know?
Yeah. Yeah.
So
So it ruined his credibility.
it ruined the
So sunk
investigation.
the case. Yeah.
I would argue that it ruined the whole investigation. If your
Mm.
lead detective is saying things like that about a person of interest or a suspect,
Yeah.
come on. I mean, it's beyond unprofessional. It is actually tarnishing the credibility and validity of his investigation.
Yeah.
So, I mean, how dare him talk like that about her? This is not even a woman he knew. And even
Mhm.
if it was a woman he had known prior, you know what I mean?
Yeah. It was
And he
so
was sending these texts
disrespectful.
to his
And
high school friends?
yeah.
Like, dude,
Yeah.
you're not
That's
in high school
terrible.
anymore, but you're talking like you are.
Yeah, they
Like,
still
grow up.
acted like it. They're in their 40s or 50s or something and still acting like this is horrible.
Yeah.
Yeah. But by the way, people are telling me to contact other attorneys who are covering this case. So I did reach out to Corey Hopkins because she's in my state. So she's the person, the attorney who decided to go ahead and file a lawsuit to try to get those sidebars or try to
Yeah.
get more info because she's so into this whole case. But I think she's not supposed to be doing YouTube due to her employment. So
Uh,
yeah, I mean I'm trying to, but of course these like bigger YouTubers, they probably don't want to come on a smaller channel. So it's kind of hard getting guests. So
Melanie Little and Emily Baker. Emily was watching Donna's trial. So
oh
she's one
yeah.
of the YouTubers I watched Donna's trial with
Hmm.
after the fact. Because for most of it I was watching with Carl. Would go with Carl Steinbeck or STS back and forth. So
Hmm.
for like Brother Counsel and Lawyer Lee and Emily, I had to go back and watch them watch the trial and hear their commentary
Yeah.
after. But Emily Baker, I know she's heavy into the Karen Reed case.
Okay.
Hmm.
Yeah. Because I was watching Lawyer today
Hmm.
when I
Hmm.
had
I
time,
watched him too. He does more like summarizing. He
Mhm.
will watch certain excerpts of the trial, but he's not watching the whole stream all day like Emily.
Mhm.
Yeah.
Okay. Well,
Mhm.
um, yeah, it's just hard to watch so many people because I have real work to do. I'm like, okay, which is the priority? These like potential clients versus YouTube and reading stuff
Of
for
course,
YouTube.
your clients are the priority because YouTube
Yeah.
isn't going anywhere, right? You can always catch up on that.
Yeah, that's true.
So
But you kind of want to cover cases when they're hot, when
that's true.
people are clicking and really want to cover
That's true,
or
but I'm talking
delve.
about consuming other people's
Mhm.
content. You can put
Yeah.
that in your watch later list and, watch it at your leisure.
Yeah, that's true. Yeah. Okay. Well, do you want to
Want to continue?
go
Yeah.
continue? Okay. Where were we?
Okay.
50?
Number 50.
Okay. Thank you,
From
guys.
mhm. From the beginning, Proctor should never have been assigned as an investigating officer, let alone the lead investigator. He grew up and resides in Canton, is a good friend of the Alberts, and had known the family for years. Proctor and Julie Albert, Brian Albert's sister in law, had each other's personal cell phone numbers. In fact, just days before Mr. O'Keefe's death, Proctor communicated with Julie Albert about babysitting Proctor's minor child. Proctor's sister, Courtney, was also a close friend of Julie. In fact, Proctor's own mother referred to the Alberts as the Proctor's quote unquote second family. The existence of these relationships was intentionally suppressed by Proctor and other members of the MSP, including Buchanan and Tully, in an effort to ensure that the House defendants were protected and that Ms. Reed's right to a fair investigation and trial were undermined. Proctor, Buchanan, and Tully engage in a corrupt and biased investigation by not investigating inside the House and interviewing House defendants as friends rather than suspects. Number 51. Proctor, Buchanan, Tully, and the MSP never searched for DNA evidence inside the House, never looked for rigid surfaces that could have caused the gash on the back of Mr. O'Keefe's head, never inspected the House defendants' bodies for indication of bruises or cuts that resulted from an altercation, and did not search the House defendants' cell phones. This allowed potential evidence to be destroyed, disposed of, removed, or simply become unrecoverable. Number 52. Proctor's, Buchanan's, and Tully's interviews of the House defendants were also outside of normal protocol. They were all interviewed either at their home, their family member's home, their lawyer's home, in the case of Brian Higgins, their lawyer's office, in the case of Brian Jr. and Caitlin Albert, their place of employment, or over the phone. These interviews were each untimely, unrecorded, and fundamentally designed to protect the House defendants, and the House defendants took full advantage of it. Number 53. Specifically, Jennifer McCabe became the point person for the House defendants in providing their false narrative to investigators. She managed and communicated details about the House defendants' messaging and the investigation itself, including visiting Proctor's and other investigators' private residences, mapping out timelines to coordinate statements with other witnesses, leading group text message chains that were later partially deleted, and planning private meetings at all hours of the day and night. Indeed, these were never the acts of innocent witnesses seeking to help an investigation concerning the death of an alleged friend. Rather, they were predicate acts of a conspiracy among a group of people with a shared goal of deflecting their criminal exposure onto someone else. Number 54, the remaining group texts that were not deleted or that were recovered later reveal some of their planning. For instance, on the evening of January 29th, Jennifer McCabe texted with her sister Nicole Albert that Kerry Roberts, who was present when Mr. O'Keefe's body was found, quote, talked to cops and kept it simple, unquote. Of course, there would be no reason to report back to other House defendants about Roberts keeping it simple, unless what really happened was more complicated. Proctor, Buchanan, and the MSP never sought these communications. Rather, they were obtained by Karen Reed's defense attorneys, repeated motions to compel access to data on Ms. McCabe's iPhone. Number 55. Later, in group texts with Jennifer McCabe and Brian and Nicole Albert, Matthew McCabe suggested having Chris Albert publicize their crafted story to a reporter, saying, quote, ask Chris to ask some questions. Tell them the guy never went in the house, unquote. As an endorsement of the plan, Brian Albert responded, exactly. Number 56. Importantly, the text messages from the House defendants' phones that were ultimately recovered and that provide a window into their conspiracy and misconduct, as well as MSP's unlawful investigation, were not the product of CPD or MSP's investigative work. Rather, based on media reports raising serious questions about MSP's investigation and the House defendants' role in Mr. O'Keefe's death, another, quote, separate law enforcement agency, unquote, began its own subsequent investigation. That investigation, and not MSP's, resulted in obtaining the House defendants' phones, taking statements from the House defendants, and conducting a, quote, a separate proceeding, unquote, all of which MSP refused to do itself. Indeed, the evidence procured by the, quote, separate law enforcement agencies, unquote, investigation demonstrates the House defendants' conspiracy and unlawful conduct, as well as MSP's bias and corruption. Number 57. Proctor and Buchanan initially interviewed the McCabes and Brian Albert on January 29th at the McCabes' home at 12 Country Lane in Canton, at which time they again falsely stated that Mr. O'Keefe never entered the Alberts' home. Buchanan and Proctor did not interview Nicole Albert and Brian Higgins until February 3rd, 2022, and did not interview Chris and Julie Albert until February 10th, nearly 2 weeks after Mr. O'Keefe's death and more than a week after Ms. Reed was arrested and charged. Before both interviews, the McCabe's and Alberts continued to coordinate their stories, as evidenced in group texts. Number 58. Proctor, Buchanan, and Tully likewise failed to conduct a meaningful investigation into Higgins' involvement. When Proctor and Buchanan interviewed Higgins on February 3rd, Higgins presented the troopers with a select set of self-curated texts between himself and Ms. Reed. They learned that Higgins and Ms. Reed had been exchanging flirtatious texts, and that Higgins reported at least one instance in which Ms. Reed and Higgins had kissed while at Mr. O'Keefe's house mere weeks before his death. Number 59. Rather than pursuing Higgins as a possible suspect, Proctor, Buchanan, and Tully neglected to investigate the matter further. They never interviewed Higgins again, even after surveillance video revealed Higgins was suspiciously hiding his face in the halls and the parking lot of CPD at 1:30 a.m. on January 29th. The video contradicts Higgins' statements about his actions that night. However, not only did Proctor, Buchanan, Tully, and MSP not investigate what Higgins was doing or what was in the bag, but they went so far as to hide this video from Karen Reed and her criminal defense attorneys for years. Reed's defense did not receive these videos until after Reed stood trial for the first time. And even after the separate law enforcement agency's investigation revealed late night phone calls between Brian Albert and Brian Higgins, MSP failed to pursue either witness further or seek a full forensic extraction of Higgins' phone or even a simple call log from his cellular provider. Number 60. When it was revealed that Ms. Reed's defense team requested the preservation of Brian Albert's and Higgins's phones in order to forensically image them, this request was allowed by the court. Both men got rid of their phones within days of one another. Higgins went so far as to drive to a military base on Cape Cod, remove the SIM card from the phone, cut the SIM card with scissors he brought with him, and destroy and dispose of the phone and card separately in two dumpsters, and then drive back home. Their destruction of their phones eliminated potentially incriminating communications between them and was a direct result of Proctor's, Buchanan's, and Tully's intentional refusal to collect important investigative evidence that would be exculpatory to Ms. Reed. Even after learning about the destruction of both witnesses' cell phones, MSP investigators had other avenues that they could have used to pursue evidence, such as cellular toll records or simply interviewing Brian Higgins and Brian Albert to inquire about the nature of the late night communications. They intentionally ignored these avenues as well. Number 61. Not only did Proctor fail to probe his friend's stories, he coordinated with them through his sister. Proctor spoke to Courtney multiple times a day and knew she was in close contact with and providing information to Julie Albert. Julie and Courtney called each other many times between February 1st and 2nd, and at least 67 times between February 1st and September 6th, 2022. Number 62. For example, as he prepared to question Chris and Julie Albert on February 10th, Proctor told his sister Courtney that the interview was, quote, not a big deal, unquote. Courtney told Proctor that Julie Albert had been nervous and wanted to give him a, quote unquote, thank you gift after the interview. To avoid scrutiny, Proctor instructed Courtney to tell Julie to give the gift to his wife, Elizabeth Proctor. Number 63. Proctor shared investigatory details with Courtney before they were public. In the same instance referenced above, when his sister informed him that Julie Albert had been, quote, so nervous, unquote, before the interview, instead of investigating further, he shrugged it off, laughed, and asked, why? But Proctor knew exactly why Julie Albert was nervous. He sought to reassure her by telling Courtney that, quote, it was fine, just a quick convo, unquote. And then after the interview, Proctor spoke to Julie on his personal cell phone in an unreported conversation. Proctor never treated the Alberts as witnesses in a murder investigation. He treated them like the family friends that they were. Number 64. At one point, leading up to some of the interviews, Ms. McCabe asked Nicole Albert if she had heard anything more about the investigation. Confident she would learn more from Julie Albert, again through Courtney, Nicole Albert responded, "We'll get more info tomorrow. Don't want to text about it." Number 65. House defendants did not, quote, want to text about, unquote, their activities and communications because they tried to hide and or lie about them. For instance, it was discovered in the second criminal trial that Ms. McCabe had lied in her sworn testimony in the first trial about not visiting 34 Fairview with Kerry Roberts on January 30th on their way to Michael Lank's house. However, while they did not text about this meeting, McCabe's cell phone location data obtained later by Reed's defense reveals that she did, in fact, visit 34 Fairview just one day after O'Keefe's death and lied about it. Number 66. The McCabes, Alberts, and Higgins all told the same false story to investigators in their interviews, and Proctor, Buchanan, and Tully accepted their coordinated statements without making efforts to corroborate their stories. Rather than investigate their friends and brethren, Proctor, Buchanan, Tully, and MSP target Karen Reed. Number 67. Instead of taking the routine, objective, and necessary steps of investigating the McCabes, Higgins, and the Alberts, Proctor, Buchanan, and Tully focused exclusively on Ms. Reed as a suspect from the start of the investigation, despite substantial evidence exonerating her and implicating others, just as the House defendants intended. Number 68. Proctor seized Ms. Reed's cell phone and her SUV within 30 minutes of interviewing her on January 29th. He arrested her 72 hours later before reviewing any surveillance from the bars or ring camera footage, before interviewing exculpatory witnesses, and before the medical examiner's official conclusion that the manner of death, quote, could not be determined, unquote, and that there were no injuries to Mr. O'Keefe's body consistent with a vehicle strike. Number 69. Much to Proctor's surprise, through the separate law enforcement agency's investigation, his contemporaneous text messages were discovered. Among them, Proctor texted with his high school friends on the evening of January 29th, the day he began his investigation. He told them that the MSP had already determined the Alberts were not going to receive any scrutiny about Mr. O'Keefe's death, even though the MSP had not at that point visited the crime scene or been inside the Alberts' home, and had performed only a cursory interview of the McCabes and Brian Albert. Number 70. Proctor told his friends that Mr. O'Keefe had been hit by a car and had not been in a fight, despite the fact that Mr. O'Keefe had suffered no injuries consistent with a vehicle strike, but he did have injuries consistent with a fight and dog attack. Proctor rejected a friend's belief that Brian Albert, the homeowner of property where Mr. O'Keefe's body was found, would, quote, receive some shit, unquote, instead agreeing with another friend's assumption that, quote, you guys, the MSP, are out to make it cut and dry since it involves cops, unquote. Proctor revealed that he had already decided he was, quote, going to put serious charges, unquote, on Ms. Reed, and that she was, quote unquote, fucked, and that there was, quote, zero chance she skates, unquote. From the outset, Proctor was determined to pin it on the girl. Number 71. Proctor's supervisors were aware of his bias and conflicted relationships in this investigation. They didn't have to guess. Proctor told them. He told them he knew the Alberts. Text messages from Proctor to Buchanan and other MSP troopers show Proctor had decided to focus suspicion on Ms. Reed to the exclusion of everyone else. He told the troopers that Ms. Reed was, quote unquote, retarded, and that he was searching for her phone for, quote unquote, nudes of her. In the text chain, Sergeant Buchanan liked Proctor's text describing Ms. Reed as retarded. Buchanan received Proctor's text and never reprimanded Proctor or addressed his improper bias and conduct. Number 72. Because he was determined to, quote, put serious charges, unquote, on Ms. Reed, Proctor ignored the fact that the Commonwealth's medical examiner could not conclude that Mr. O'Keefe's death was a homicide, determining instead that the manner of his death could not be determined. The medical examiner also refused to conclude that Mr. O'Keefe died as a result of being struck by a vehicle, and later testified at trial that his injuries were not consistent with a car strike. Proctor later admitted that, in his entire career, he had never seen a homicide investigation where the medical examiner could not determine the manner of death. But he remained undeterred in his quest to charge Ms. Reed. As he later admitted, the medical examiner's refusal to rule the death a homicide did not matter to him, quote, because either way, Ms. Reed was going to be charged, unquote. Proctor and Buchanan plant certain evidence and make false statements in court and other legal documents to frame Karen Reed. Number 73. Proctor made this investigation cut and dry, quote unquote, by manufacturing a case against Ms. Reed. A crucial first step was to ensure that the crime scene and evidence was not secured. This was in violation of MSP policy and well-established best practices for critical incident investigations. Specifically, the MSP crime laboratory requires proper processing of evidence at major crime scenes, including, quote, crime scene photography and evidence processing and recovery of latent fingerprint, footwear, and tire track evidence, unquote. Neither the MSP troopers involved in the investigation nor the CPD police officers on the scene secured the Alberts home or the area where Mr. O'Keefe's body was found. The MSP did not take any photographs of the house, including any part of the yard where Mr. O'Keefe's body was found, until February 1st, more than 3 full days later. No photographs were ever taken of the inside or garage of 34 Fairview. This intentional departure from established protocols permitted Proctor and Buchanan to generate false incriminating evidence against Ms. Reed and give the House defendants time to destroy the actual evidence. Number 74. By approximately 2:30 p.m. on January 29th, before he had even met or interviewed Ms. Reed or seen her Lexus SUV, Proctor had already ordered seizure of the vehicle at her parents' home in Dighton. By 4:17 p.m., the vehicle was in MSP's physical possession. The vehicle was then towed to the CPD Sallyport, quote unquote, even though the MSP was at least two closer barracks. What? Even though the MSP has at least 2 closer barracks and Massachusetts was in the middle of an historic nor'easter. Proctor knew he had more leeway to manipulate evidence regarding the SUV at CPD than at MSP's facilities, and he knew he needed to have that evidence in close proximity to the crime scene at 34 Fairview Road. Number 75. Before the vehicle arrived at the garage, Ms. Reed's Lexus taillight had a minor crack but was intact. The crack occurred when Ms. Reed backed into Mr. O'Keefe's car at 5 a.m. that morning as she was leaving to search for him. That incident was captured on video. 76. Buchanan and Proctor followed the vehicle from Dighton and arrived at CPD at 5:30 p.m., just moments after the tow truck with the Lexus. At some point after the vehicle arrived at the Sallyport, the right rear tail light was almost entirely destroyed. Video taken from different angles in the Sallyport shows Buchanan, Proctor, Canton Police Chief Ken Berkowitz, and other individuals near the taillight, but notably, no video captures the taillight's appearance at the precise time it arrived at the Sallyport. The available surveillance video from the Sallyport, as well as a CPD access card swipe log obtained by a separate law enforcement agency, reveal seemingly unfettered access to the Sallyport by a myriad of individuals throughout the evening of January 29th, including just before and just after 5:30 p.m. Number 77. One or more of them destroyed the tail light, secretly took pieces of it into their possession, and then planted some of them in various places at 34 Fairview and on Mr. O'Keefe's clothes. Number 78. Knowing that there were video cameras both inside and outside the Sallyport, Proctor and Buchanan worked together to obscure their role in manipulating the right rear tail light and then ultimately to present false evidence at the first criminal trial. Specifically, Proctor directed Buchanan to secure video footage from surveillance cameras located both inside and outside the Sallyport garage, which he did. These videos were manipulated in two significant ways. Two significant ways. First, a critical 42-minute portion was deleted from the footage from the Sallyport front wall camera. The portion from 5:08:02 p.m. to 5:50:50 p.m., which included the exact time Ms. Reed's Lexus arrived in the garage. This footage would have shown that the taillight was intact. Second, footage from the Sallyport back wall camera was inverted, which made the right side of Ms. Reed's vehicle appear to be the left side and vice versa. Another camera, quote, main driveway side exterior, captured the back end of the Lexus as it arrived at CPD, but was too grainy to decipher the condition of the passenger tail light. Number 79. The videos from inside and outside the Sallyport and Proctor's request for Buchanan to obtain it was intentionally hidden from Karen Reed and her defense attorneys for more than 2 years to avoid scrutiny. The video was then sprung on them immediately before and during the first criminal trial. One driveway camera's footage was not revealed to the defense until just prior to the start of the second trial. In fact, Buchanan presented one part of the video during his direct testimony under questioning by the Assistant District Attorney Adam Lally. Buchanan narrated the video to the jury, correctly identified that Proctor was at the rear of the vehicle, but claimed that he never approached the right rear tail light area of the vehicle. That testimony, however, was entirely false. As he well knew, the video that Buchanan authenticated as fair and accurate, quote unquote, was actually neither fair nor accurate because it had been inverted. Proctor was actually behind the right tail light for a significant period, but because it was inverted, it appeared in the video that he was behind the left tail light. They hoped this would allow Buchanan to lie about this issue at trial without detection. With this video and Buchanan's false testimony, the MSP, Proctor, and Buchanan attempted to mislead the jury in order to conceal the tampering with and planting of tail light material. Number 80. Proctor and Buchanan also took tail light pieces from the Sallyport, brought them back to 34 Fairview to plant them in the location where Mr. O'Keefe's body was found, and then falsify various documents in an attempt to hide their conduct. Number 81. In warrant applications to the Stoughton District Court and Norfolk Superior Court for searches of Google's electronic records, ring videos, Ms. Reed's phone, Ms. Reed's vehicle, cell tower records, and other sources of information, Proctor swore he seized Ms. Reed's vehicle from her parents' home at 5:30 p.m. on January 29, 2022, and had the vehicle towed to the CPD. Reports shared by the Dighton Police Department in 2023 reveal that the Lexus was towed from Dighton at 4:17 p.m. Proctor's assertion that he seized it at 5:30 p.m. was intentionally false to hide the fact that the car was in police custody for 73 minutes longer than indicated in his sworn affidavits. Number 82. Proctor maintained that false narrative because it would hide the exact time frame when he had the opportunity to remove pieces of the tail light from Ms. Reed's vehicle and bring them back to the house so that he could later claim the pieces had been there since approximately 12:30 a.m. on January 29th. However, unbeknownst to him, driveway video from the Reed residence in Dighton and a report written by the Dighton Police Report revealed Proctor's lie and revealed the true and accurate time the Lexus SUV came into MSP's possession. 83. Proctor also deposited the SUV taillight pieces that he and others removed from the vehicle in the Sally Port on Mr. O'Keefe's clothes. Proctor retrieved Mr. O'Keefe's clothes from the floor of the hospital where he was pronounced deceased. Instead of securing the clothes in a sealed container or bag as protocol requires, Proctor and Buchanan drove them around in his car all day and then placed them in the Norfolk County District Attorney's office for at least 6 days, where they were accessible to Proctor, Buchanan, and any other MSP troopers. 84. Proctor and Buchanan failed to create a log to document the chain of custody of the clothing. Therefore, and by design, there is no record of when, how many times, and under what circumstances Proctor and Buchanan touched, manipulated, handled, or otherwise tampered with that clothing. Number 85. The MSP Evidence Submission Handbook dictates that chain of custody begins at the time of collection and that the collector, quote, seal evidence packages as soon as possible after collection to ensure integrity of evidence items and limit loss of transient evidence, unquote. 86. Here, in violation of MSP's stated policies, the chain of custody for all of John O'Keefe's clothing, as well as dozens of pieces of taillight material, does not begin until March 14th, 2022, nearly 2 months after it was collected, when Proctor finally submitted it to the MS Crime Lab. At some point before providing those clothes to the crime lab, Proctor and/or Buchanan placed pieces of the SUV taillight on them, where they were then identified by the crime lab in 2023. 87. Proctor also planted pieces of glass on the bumper of Ms. Reed's SUV while it was in his possession at the CPD Sallyport garage, which he then claimed to have, quote-unquote, recovered later on February 1st. Proctor planted this evidence to make it look like these shards originated from a cocktail glass that Mr. O'Keefe was holding when he exited the Waterfall Bar. Evidently, Proctor did not plan on Karen Reed's defense attorneys insisting on forensic testing on the glass shards, which showed that they did not match the cocktail glass in Mr. O'Keefe's possession. In fact, the 5 glass pieces originated from multiple different sources. One shard of glass on the bumper did match another piece of glass that had been in Proctor's possession during the investigation. The only way for the glass to have ended up on the SUV bumper is that Proctor planted it there in an attempt to connect the vehicle to the death of Mr. O'Keefe. Okay, break.
Okay. Should I attempt to read something?
Sure.
Or that could turn off viewers. But with my speech problems, which have gotten worse over the last few years, I can actually speak a lot better doing silly voices.
Yeah, I noticed
if you guys want me to read this in a Donna Adelson fake New York accent, let me take a stab at it just to give poor Nadine a break.
That'll be fun.
Okay, let's just do a page. Donna Adelson voice.
Yeah.
Other aspects of the conflicted and corrupt investigation. 88. Proctor's, Buchanan's, and MSP's investigation was rife with other examples of corruption and bias. For example, despite evidence that Brian Albert may have had video surveillance at the house, neither Proctor nor Buchanan nor any other member of the MSP issued subpoenas to Ring or any other home surveillance company, and no one questioned any other member of the Albert family about the presence of video monitoring. 90. Proctor and the MSP also failed to track down other important witnesses and evidence. For example, Brian Lofrun, a town of Canton snowplow operator, turned out to be one of the most significant witnesses in the entire criminal trial. Proctor and his colleagues never spoke to him during their investigation, and only did so once Lofrun was interviewed by a separate law enforcement agency and provided statements inconsistent with the MSP's narrative, 18 months after Ms. Reed was already indicted and awaiting trial. 91. Specifically, Mr. Lofren drove his snowplow by the house multiple times in the early morning hours of January 29th, including at 2:30 a.m. and 3:30 a.m. He reported that there was no body on the lawn at 34 Fairview, nor cars on the street in front of the house at 2:30 a.m. Mr. Lofren believes he would have seen a body had it been on the lawn where Mr. O'Keefe was found several hours later. Okay, is that enough? Are people leaving? Everyone's like, what the heck is this?
People are laughing. Donna Adelson reading a complaint.
Fake New York accent done by some Asian person who grew up in Georgia. Okay. Okay, you ready?
But it is interesting how when you're doing the voice, it doesn't
shake as much.
Your shaking goes away.
The high-pitched stuff doesn't cause my vocal tremor as much. Okay.
Okay, so number 92 are we on?
Or instead.
Okay, instead, the second time he drove by the house around 3:30 a.m., Mr. Lofren ran a Ford Edge in front of the Alberts home that had not been there an hour before. He saw a Ford Edge in front of the Alberts home that had not been there an hour before, but which was then parked where Mr. O'Keefe's body was later found. Brian Albert drove a Ford Edge at the time. Number 92. However, the Ford Edge was gone by the time Ms. Reed arrived to the house around 6 a.m., and in its place she discovered Mr. O'Keefe's body. Proctor, Buchanan, and Tully never made any effort during the actual investigation to track down Mr. Lofren or any information relating to the Ford Edge. Number 93. Proctor also secretly made efforts to protect other Albert family members during the investigation who may also have had a role in Mr. O'Keefe's death. Witness Judy Nagel told Proctor that Colin Albert, Brian Albert's nephew, had been present at the house the night of January 28th through 29th. But Proctor omitted his name from his official summary of Ms. Nagel's interview, even though he listed all others who had been present at the house with Colin. When Ms. Reed's attorneys filed a motion to obtain Proctor's notes, his handwritten memorialization of the Judy Nagel interview mirrored almost exactly what was typed up in his police report, except for the words, quote-unquote, Colin Albert. Number 94. Proctor's interactions with Kevin Albert, Brian Albert's brother, during the investigation also demonstrate his close relationships with the Albert family, as well as his propensity for violating MSP rules and Massachusetts criminal laws. Repeatedly, Proctor used his personal cell phone to speak with Kevin, a CPD officer, instead of official channels when he coordinated interviews of witnesses, even though CPD was recused from the investigation. Number 95. Further, in the middle of Proctor's investigation in the summer of 2022, it was discovered that Proctor and Kevin Albert were out together drinking alcohol and driving in Proctor's cruiser on Cape Cod. At the end of the night, Kevin Albert forgot to bring home his gun and badge and left them in Proctor's cruiser. Their drinking and driving in Proctor's MSP vehicle violated both MSP policies as well as various Massachusetts criminal statutes and further highlights the conflicted nature of MSP's investigation. Number 96. Moreover, because of their close relationship, Proctor, Buchanan, and Tully worked together with CPD in hiding certain videos from Karen Reed's criminal defense team. Specifically, upon information and belief, MPD and CPD collaborated to keep exculpatory surveillance video from Karen Reed's criminal defense team in preparation for the first trial. Those videos captured Brian Higgins' activities in the CPD parking lot and inside the police station shortly after the physical altercation at the house that led to Mr. O'Keefe's death. They demonstrated that Higgins' statements about his post-house party activities on the night of Mr. O'Keefe's death were not accurate. Upon information and belief, CPD knew it had this evidence and worked with MSP to keep it from Ms. Reed. Additionally, upon information and belief, CPD set its quote-unquote auto-delete function for saving certain surveillance videos from the Sallyport to, quote, 30 days, unquote, therefore assuring the immediate destruction of likely additional exculpatory evidence. The 30-day auto-delete setting conflicts with the fact that CPD videos were shared with the defense over the course of 3 years. Therefore, either the setting was changed to prevent a defense expert from auditing the footage, which is when the 30-day setting was discovered, or the footage was obtained within 30 days of January 29th and withheld from the defense. The indictments, trials, and aftermath. Number 97. Ms. Reed was arrested on February 1st, 2022, pursuant to a criminal complaint charging her with manslaughter, among other charges. She was required to post $50,000 for bail, and the court imposed several other conditions of release, including loss of her driver's license and stay-away orders from the O'Keefe family and John O'Keefe III's home. Number 98. Ms. Reed was later rearrested on June 9th, 2022, after being indicted for second-degree murder, manslaughter, and leaving the scene of an accident resulting in death. Her bail was set at $100,000 by the Norfolk County Superior Court. In February of 2023, her bail was reduced to $80,000 at the defense's request. Number 99. Ms. Reed was tried twice by the Commonwealth. The first trial started in April 2024 and ended on July 1st, after the court ordered a mistrial because of a hung jury. Number 100. On June 18, 2025, following another nearly 2-month trial, Ms. Reed was acquitted of all charges associated with the death of John O'Keefe, murder, manslaughter, and leaving the scene of an accident resulting in death. For the first time in 3.5 years, Karen Reed was able to leave court knowing that the forces aligned against her had failed to convince a jury to buy their deception. Number 101. Beginning in January 2022, the defendant's actions have had profound effect on Ms. Reed. She lost her employment and income. She lost her professorship. She lost her private health insurance. She lost her car and her driver's license. She lost her house. Her reputation, both personally and professionally, was utterly destroyed. She incurred multiple millions of dollars in debt for legal fees and additional millions in expert fees and costs. In addition, after being arrested twice, jailed twice, and twice tried twice, she has suffered years of intense stress and emotional harm. Worried that she would be imprisoned for the rest of her natural life for a crime she did not commit. 102. Ms. Reed suffers from both Crohn's disease and multiple sclerosis. As documented under seal with the criminal court, Ms. Reed has undergone tens of surgeries to manage her illnesses prior to January 29th, 2022, and endured a blood infusion just months before Mr. O'Keefe's death. In the aftermath of the charges, 2 arrests, and during both trials, Ms. Reed suffered a well-documented exacerbation of her symptoms amid the stress, anxiety, and emotional and physical impacts of being wrongfully accused of murder. While fighting for her freedom against a corrupt prosecution, Ms. Reed underwent dozens upon dozens of documented medical procedures and treatments to attempt to address her health issues. 103. The defendants concocted a plan, executed that plan, and framed an innocent woman, and they are now responsible for these extraordinary damages Ms. Reed has suffered at their hands. MSP investigates and punishes Proctor, Buchanan, and Tully for their misconduct during the investigation. 104. Proctor wrote more than one-third of the police reports in this case, testified at the state grand jury 3 separate times, interviewed every member of the Albert and McCabe families, had possession, at least until March 14, 2022, of all of John O'Keefe's clothing and all of the taillight pieces found broken from the housing, processed Mr. O'Keefe's Chevrolet Traverse the day after Ms. Reed was arraigned, and had access to and reviewed all the ring videos, had access to and reviewed the surveillance from C.F. McCarthy's, and possession of all of the CPD Sallyport and driveway videos, and numerous other critical investigative activities. And yet, once evidence of Proctor's conflicts and lies became public, he was extricated from this case in an effort to hide him from the jury and sanitize the compromised investigation, while Ms. Reed was forced to trial not once, but twice. Number 105. Ultimately, Michael Proctor was relieved from duty and transferred out of the detective unit of the Norfolk County District Attorney's Office on July 7, 2024, mere days after the conclusion of Ms. Reed's first trial. Proctor was terminated from the MSP on March 19, 2025. Upon a release from the district attorney of more implicating text messages from Proctor's phone, on October 18, 2025, Proctor officially ended his appeal with the Civil Service Commission. Number 106. On September 23, 2024, an MSP internal affairs investigation found Yuri Buchanan, quote, failed to perform his supervisory duties in an ongoing investigation, unquote. On July 7, 2025, Buchanan was transferred out of NDAO detective unit and reassigned to an administrative role in another division. Thank you all. I'll take some more water now. Thank you.
Okay, can I try?
Mm-hmm.
Should I try again?
Go ahead,
just to
Donna.
save poor Nadine. I'm sorry about this, but okay, where are we? 107. Okay.
Yeah, we're almost there. Maybe we can finish.
Okay,
Yeah.
one more page. I'll read like the rest of this page. On October 18th, 2024, Brian Tully was disciplined and reassigned from SPDU and stripped of his detective designation. Tully was given special dispensation by Norfolk County District Attorney Michael Morsey to continue detective work on the Reed case, despite his demotion because of his behavior on this case. 108. Upon information and belief, MSP troopers David DeCiccio and Jeffrey Kotkowski were also disciplined for their misconduct associated with MSP's investigation of Ms. Reed. Number 5, counts. Count 1, 42 USC 1983. Malicious prosecution under the Fourth Amendment. against Proctor, Buchanan, Tully. 109. The preceding paragraphs are incorporated herein by reference. 110. Proctor, Buchanan, and Tully violated Ms. Reed's Fourth Amendment rights by engaging in a malicious prosecution of Ms. Reed by causing her to be seized pursuant to legal process, unsupported by probable cause. 111. The criminal proceedings against Ms. Reed terminated in her favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. Footnote 4. After making presentment pursuant to GL C-258 Section 4, Ms. Reed will add counts against A. MSP for negligent training, supervision, and retention of MSP troopers, including Proctor, Buchanan, and Tully, and B. the Town of Canton for negligent oversight of the investigation into Mr. O'Keefe's death and of its own officers and facilities. Okay, Nadine, ready to take over again?
Sure,
Okay,
thank you.
go ahead.
Number 112, Proctor, Buchanan, and Tully caused Ms. Reed to be seized without probable cause as described above, including, but not limited to, by A. leading, handling, and participating in the O'Keefe investigation, even though Proctor was conflicted due to personal relationship with various witnesses, suspects, and potential suspects, which conflict led to Ms. Reed's unlawful treatment. B. Handling the investigation even though Proctor had an extreme and personal negative bias towards Karen Reed, which bias led to Ms. Reed's unlawful treatment. C. Violating MSP's rules, policies, and procedures in all aspects of the investigation. D. Planting, fabricating, and manipulating evidence, falsifying documents, preparing false affidavits, and committing perjury. E. Failing to secure evidence and the crime scene, obtain evidence, timely and appropriately interview suspects, and investigate the Alberts, McCabe's, or Higgins, and allowing them to destroy potentially exculpatory evidence. F. Failing to consider and present exculpatory evidence to prosecutors and the grand jury investigating Mr. O'Keefe's death, such as the evident dog bite injuries on Mr. O'Keefe's arm, and evidence that his injuries were caused by an altercation and not a vehicle strike, such as the lack of lower body trauma. 113. Following her indictment by a grand jury, Ms. Reed was rearrested without probable cause, forced to pay a $100,000 bond to be released from custody, and required to comply with numerous pretrial release provisions. These post-arraignment deprivations of her liberty constitute seizures under the Fourth Amendment. 114. Those deprivations continued during Ms. Reed's second trial, in part because of Proctor's false testimony at Ms. Reed's first trial. Among other things, Proctor falsely testified that A. When he first saw the taillight on Ms. Reed's car at Ms. Reed's parents' house in Dighton, it had large pieces missing, and the shattered taillight displayed at the first trial, as photographed on February 1st, 2022, was in the same condition as on January 29th. B. He and Buchanan never touched any part of Ms. Reed's vehicle when it was stored in the CPD Sallyport. C. He retrieved taillight pieces on subsequent searches at the Alberts' home when he knew he had deposited or arranged for someone to deposit taillight pieces at the property. D. Chris and Julie Albert were his loose acquaintances rather than friends. And E. His statements and sworn affidavits all claiming the Lexus was seized at 5:30 p.m. and that he arrived in Dighton at 4:30 p.m. were quote-unquote typos. 115. Thus, Proctor, Buchanan, and Tully, acting under color of law, violated Ms. Reed's Fourth Amendment rights against unreasonable searches and seizures. 116. As a proximate result of this misconduct, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death and made to defend herself in two trials in the Superior Court for Norfolk County, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. 117. In addition to an award of damages for these harms, Ms. Reed is entitled to her attorney's fees under 42 U.S.C. 1988, costs, interest, and punitive damages. Count 2, 42 U.S.C. 1983, supervisor liability against Buchanan and Tully in their individual capacities. 118. The preceding paragraphs are incorporated herein by reference. 119. A supervisor is liable under 42 U.S.C. 1983 when the supervisor supervises, trains, or hires a subordinate with deliberate indifference towards the possibility that the subordinate's deficient performance will result in deprivation of an individual's constitutional rights. 120. Buchanan and Tully knew, or should have known, that there was a grave risk that Proctor would fail to investigate the Alberts, with whom he had a close personal relationship, which he had disclosed. 121. They also knew, or should have known, that there was a grave risk Proctor would wrongly seek to have Miss Reed charged, given the manifest bias evidenced in his text messages, which were sent to Buchanan, among others. 122. Buchanan and Tully could have taken easily available steps to avoid a constitutionally deficient malicious prosecution of Ms. Reed. Those measures include, but are not limited to, 1. Replacing Proctor with an unbiased investigator that had no personal relationship with anyone involved in Mr. O'Keefe's death. 2. Safeguarding the crime scene and the physical evidence, including Mr. O'Keefe's clothing and 47 pieces of taillight material, to prevent anyone from planting, manufacturing, or manipulating evidence. 3. Initiating timely searches at the Alberts' house. And 4. Quickly seizing the cell phones and other forms of electronic evidence in the possession of the Alberts, the McCabe's, and Higgins, which would have prevented their later manipulation and destruction. 123. By not taking any of those measures, Buchanan and Tully permitted Proctor, and Tully permitted Buchanan to violate Ms. Reed's Fourth Amendment rights against unreasonable searches and seizures, and thus themselves violated Ms. Reed's Fourth Amendment rights. Number 124. In these ways and others, Buchanan's conduct constituted condonation of and/or acquiescence to Proctor's behavior or gross negligence amounting to deliberate indifference. Number 125. In these ways and others, Tully's conduct constitute condonation of or acquiescence to Buchanan's and Proctor's behavior or gross negligence amounting to deliberate indifference. Number 126. As a proximate result of their breaches, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. 127. In addition to an award of damages for these harms, Ms. Reed is entitled to her attorney's fees under 42 U.S.C. 1988, costs, interest, and punitive damages. Count 3. 42 U.S.C. 1983, conspiracy to deprive Ms. Reed of her Fourth Amendment rights against Proctor, Buchanan, Tully, the Alberts, the McCabe's, and Higgins. Number 128, the preceding paragraphs are incorporated herein by reference. Number 129, Proctor, Buchanan, Tully, the Alberts, the McCabe's, and Higgins shared a common design and acted in concert to frame Ms. Reed for Mr. O'Keefe's death. Number 130. As part of their concerted efforts, and among their many other misrepresentations, the Alberts, McCabe's, and Higgins agreed with each other to tell investigators that Mr. O'Keefe never entered the house, that they did not see Mr. O'Keefe in the house that night, and that Ms. Reed made inculpatory statements on the morning of January 29th. (131) When they made these statements, the House defendants did so only because they were aware that Proctor, Buchanan, and Tully would also act similarly by solely investigating Ms. Reed. Number 132. Proctor, Buchanan, and Tully knew, or should have known, that the statements made to them by the House defendants were false, and that obvious and easily obtainable evidence existed demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation, during which he was beaten up, fell back, gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties to the House defendants, Proctor, Buchanan, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for and implicit direction to conduct an investigation that solely targeted Ms. Reed, to the exclusion of everyone and anyone else. 133. In furtherance of this plan, among other unlawful conduct, Proctor, Buchanan, and Tully agreed: A. To continue to handle the investigation even though they had personal relationships with suspects in the murder, which led to unlawful and unfavorable treatment of potential suspects. B. To continue to handle the investigation even though they had biases against investigating the House defendants because of the House defendants' ties to law enforcement. C. To continue to handle the investigation even though they had exhibited an extreme and personal negative bias towards Karen Reed. D. To violate rules, policies, and procedures in all aspects of the investigation. E. To plant, manufacture, and manipulate evidence, falsify documents, and commit perjury. F. To not secure evidence and the crime scene. G. To not investigate and obtain available evidence or timely and appropriately interview suspects. And H. To not investigate the Alberts, McCabe's, or Higgins. Number 134. The McCabe's and Alberts coordinated their efforts through text messages, phone calls, and conversations. Higgins and Brian Albert coordinated their efforts through telephone calls and texts on their phones, which were later destroyed or discarded. Finally, Proctor, Buchanan, and Tully coordinated with the Alberts and McCabe's, though Proctor's sister, Courtney, through. Is that supposed to be through? Finally, Proctor, Buchanan, and Tully coordinated with the Alberts and McCabe's through Proctor's sister, Courtney, who communicated frequently with Julie Albert. 135. Acting pursuant to the plan, Proctor and Buchanan interviewed the McCabe's and Brian Albert in a cursory manner, and all at the same location, midday on January 29th, and Nicole Albert on February 3rd. Proctor and Buchanan only interviewed Higgins once at his attorney's home and did not secure or search his phone or search for communications between him, the Alberts, and the McCabe's. Proctor and Buchanan did not search the Alberts' phones or home where there was likely evidence of Mr. O'Keefe's murder. Brian Albert and Higgins destroyed or discarded their phones, destroying evidence of the murder and cover-up. 136. As a result of the conspiracy between and among them, Proctor, Buchanan, and Tully never investigated the House defendants, and instead Ms. Reed was wrongfully arrested and prosecuted in violation of her Fourth Amendment rights. 137. Proctor, Buchanan, Tully, and the House defendants acted in unison and had a peculiar power of coercion over Ms. Reed because Proctor, Buchanan, and Tully were the state police employees investigating Mr. O'Keefe's murder, and the House defendants were able to direct that investigation solely towards Ms. Reed because of their personal and professional connections to Proctor, Buchanan, and Tully, and their superior knowledge of police and criminal investigations as a result of their own work in and connection to law enforcement. 138. The proximate result of Ms. Reed's wrongful prosecution was her loss of employment, reputational damages, millions of dollars of legal expenses, and serious emotional and physical distress and injury. Number 139. In addition to an award of damages for these harms, Ms. Reed is entitled to her attorney's fees under 42 U.S.C. 1988, costs, interest, and punitive damages. Count 4. Massachusetts Civil Rights Act, MCRA, against Proctor, Buchanan, Tully, Alberts, McCabe's, and Higgins. Number 140. The preceding paragraphs are incorporated herein by reference. 141. Proctor, Buchanan, Tully, and the House defendants interfered or attempted to interfere with Ms. Reed's exercise or enjoyment of her rights under the federal and Commonwealth constitutions and laws through threats, intimidation, or coercion. Number 142. Among other acts, by manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts and Higgins' phones, and ignoring exculpatory evidence such as the dog bite injuries and lack of injuries consistent with a vehicle strike, Proctor and Buchanan caused Ms. Reed's wrongful indictment, arrest, and prosecution, and thereby interfered and attempted to interfere with her rights under the Fourth Amendment to the United States Constitution and Article 14 of the Massachusetts Declaration of Rights. 143. By falsely representing that Mr. O'Keefe never entered the Albert house, and by relocating his body to the location on the Alberts property where they could claim Ms. Reed dropped off Mr. O'Keefe, the Alberts, the McCabe's, and Higgins caused Ms. Reed's wrongful indictment, arrest, and prosecution. Brian Albert and Brian Higgins also caused Ms. Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. The House defendants thereby interfered and attempted to interfere with Ms. Reed's rights under the Fourth Amendment to the United States Constitution and Article 14 of the Massachusetts Declaration of Rights. 144. Ms. Reed's wrongful indictment, arrest, and prosecution were intrinsically coercive under Massachusetts law. 145. Moreover, the House defendants and Proctor's, Buchanan's, and Tully's conduct amounted to threats, intimidation, and coercion designed to force Ms. Reed to give up her defense and plead guilty to a crime she did not commit. Number 146. As a proximate result of defendants' actions, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional distress and injury. 147. In addition to an award of damages for these harms, Ms. Reed is entitled to her costs, interest, and attorney's fees under GL 1211I. Count 5, common law malicious prosecution against Proctor, Buchanan, Tully, the Alberts, the McCabe's, and Higgins. Number 148. The preceding paragraphs are incorporated herein by reference. 149. By manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts and Higgins' phones, and ignoring exculpatory evidence such as Mr. O'Keefe's dog bite injuries and lack of injuries consistent with a vehicle strike, Proctor, Buchanan, and Tully caused Ms. Reed's indictment, arrest, and prosecution. Number 150. Ms. Reed's indictment, arrest, and prosecution occurred without probable cause because they were based on false, manufactured, manipulated, and planted evidence, and because Proctor, Buchanan, and Tully ignored exculpatory evidence and allowed potentially exculpatory evidence to be destroyed. 151. These criminal proceedings were instituted with malice as evidenced by Proctor's, Buchanan's, and Tully's knowledge that it was based on false evidence, Proctor's, Buchanan's, and Tully's bias and ill will towards Ms. Reed, and for the improper purpose to protect Proctor's friends and acquaintances, the Alberts. Number 152, the criminal proceedings terminated in Ms. Reed's favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. Number 153, by falsely representing that Mr. O'Keefe never entered the Albert house and by relocating his body to the location on the Albert property where Jennifer McCabe would claim Ms. Reed dropped off Mr. O'Keefe, Brian and Nicole Albert, the McCabes, and Higgins caused Ms. Reed's wrongful indictment, arrest, and prosecution. Brian Albert and Brian Higgins also caused Ms. Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. Number 154, as a proximate result of defendant's actions, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional distress and injury. Count 6, intentional infliction of emotional distress against Proctor, Buchanan, Tully, Alberts, McCabes, and Higgins. Number 155. The preceding paragraphs are incorporated herein by reference. 156. By manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts and Higgins' phones, and ignoring exculpatory evidence such as Mr. O'Keefe's dog bite injuries and lack of injuries consistent with a vehicle strike, Proctor, Buchanan, and Tully caused Ms. Reed's indictment, arrest, and prosecution. 157. By falsely representing that Mr. O'Keefe never entered the Albert house and by relocating his body to the location on the Albert property where Jennifer McCabe claimed Ms. Reed dropped Mr. O'Keefe, the Alberts, the McCabes, and Higgins caused Ms. Reed's wrongful indictment, arrest, and prosecution of Ms. Reed. Brian Albert and Brian Higgins also caused Ms. Reed's wrongful indictment and arrest and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. They're just repeating the same thing. 158, the defendants knew or should have known their conduct would cause Ms. Reed emotional distress since it would lead to her prosecution for murder and other crimes, and the conduct did cause and is causing Ms. Reed severe emotional and physical distress. 159, the defendant's conduct perverted the justice system, allowed Mr. O'Keefe's true killer to escape liability, and threatened to imprison Ms. Reed. It is the type of behavior that threatens civilized society and is therefore extreme and outrageous. 160. As a proximate result of defendant's actions, Ms. Reed suffered serious emotional and physical distress and injury. Count 7, civil conspiracy against Proctor, Buchanan, Tully, the Alberts, McCabes, and Higgins. 161. The preceding paragraphs are incorporated herein by reference. 162. Proctor, Buchanan, Tully, the Alberts, the McCabes, and Higgins shared a common design and acted in concert to frame Ms. Reed for Mr. O'Keefe's death. 163. As part of their concerted efforts, and among their many other misrepresentations, the Alberts, McCabes, and Higgins agreed with each other to tell investigators that Mr. O'Keefe never entered the house, that they did not see Mr. O'Keefe in the house that night, and that Ms. Reed made inculpatory statements on the morning of January 29th. 164. When they made these statements, the House defendants did so only because they were aware that Proctor, Buchanan, and Tully would also act similarly by solely investigating Ms. Reed. 165. Proctor, Buchanan, and Tully knew or should have known that the statements made to them by the House defendants were false, and that obvious and easily obtainable evidence existed, demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back, gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties to the House defendants, Proctor, Buchanan, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for and implicit direction to conduct an investigation that solely targeted Ms. Reed to the exclusion of everyone and anyone else. Number 166. In furtherance of the conspiracy, Proctor, Tully, and Buchanan agreed to fabricate, plant, and manipulate evidence purporting to show that Ms. Reed's vehicle hit Mr. O'Keefe. Pursuant to their plan, Proctor, Buchanan, and Tully carried out multiple overt acts, including damaging the taillight on Ms. Reed's vehicle while it was in the town of Canton Sallyport, not securing the crime scene, and depositing taillight pieces on January 29th prior to the MSP CERT team's arrival on site. In addition, Proctor deposited some of the broken taillight pieces on Mr. O'Keefe's clothing while the clothing was in his unprotected custody. Proctor also deposited glass alleged to have been from a cocktail glass on the bumper of Ms. Reed's Lexus SUV sometime prior to the vehicle's processing by MSPCL on February 1st, 2022. Number 167. Another part of the conspiracy was to take coordinated steps to ignore and destroy potentially exculpatory evidence that pointed to other suspects like the Alberts and Higgins. The McCabe's, the Alberts, and Higgins coordinated through text messages, phone calls, and on information and belief conversations. Higgins and Brian Albert coordinated through telephone calls and, on information and belief, texts on their phones, which were later destroyed or discarded. Finally, Proctor coordinated with the Alberts and McCabe's through his sister, Courtney, who spoke frequently with Julie Albert. 168. Acting pursuant to the plan, Proctor and Buchanan interviewed the McCabe's and Brian Albert in a cursory manner the morning of January 29th and Nicole Albert on February 3rd. All told the same false story that Mr. O'Keefe never entered the Alberts' house. Proctor, Buchanan, and Tully also only interviewed Higgins once with his attorney at his attorney's home and did not secure or search Higgins's phone or search for communications between him, the Alberts, and the McCabe's. Pursuant to the coordinated plan, Proctor, Buchanan, and Tully also did not search the Alberts' phones or home where there was likely evidence of Mr. O'Keefe's murder. Further, Brian Albert and Higgins destroyed or discarded their phones, destroying evidence of the murder and cover-up. Number 169. Following Mr. O'Keefe's death, among other acts, the McCabe's and Alberts agreed to make it look like Mr. O'Keefe died due to exposure after being hit by Ms. Reed's car. As part of this common plan, Brian Albert and Higgins, both law enforcement officers familiar with investigations, communicated at 2:22 a.m. on January 29th after Higgins left the house. Shortly thereafter, as part of the plan, Jennifer McCabe deleted a Google search at 2:27 a.m. on January 29th for how long it takes a person to die in the cold. One or more of them then relocated Mr. O'Keefe's body and deposited it on the front of the Alberts' house, where Jennifer McCabe claimed Ms. Reed had dropped Mr. O'Keefe off earlier. The McCabe's and Alberts then coordinated what they would say to the police, all of them falsely telling investigators that Mr. O'Keefe never entered the house. 170. Proctor, Buchanan, Tully, and the House defendants acted in unison and had a peculiar power of coercion over Ms. Reed because Proctor, Buchanan, and Tully were the state police employees investigating Mr. O'Keefe's murder, and the House defendants were able to direct that investigation solely towards Ms. Reed because of their personal and professional connections to Proctor, Buchanan, and Tully, and their superior knowledge of police and criminal investigations as a result of their own work in and connection to law enforcement. Number 171, Proctor's, Buchanan's, Tully's, and the House defendants' conduct described herein were unlawful and tortious. Tortious? Judy, you're the
Tortious.
tortious.
Yeah.
Okay, I said it right
Tortious.
the first time.
Yeah, that's fine. We're almost done. Yay. Great going.
Among other things, they constitute intentional infliction of emotional distress, negligence, common law malicious prosecution, and violations of Ms. Reed's rights pursuant to the United States Constitution and the Massachusetts Declaration of Rights. 172. As a proximate result of defendants' actions, Ms. Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. Jury demand. Yeah, we're almost done. Ms. Reed respectfully requests a jury trial on all matters so triable. Prayer for relief. Wherefore, Ms. Reed respectfully requests that the court grant her the following relief. A. Enter judgment in her favor and against each relevant defendant on each count of this complaint. B. Award her damages in an amount to be calculated at trial, along with pre- and post-judgment interest, costs, and expenses. C. Award her reasonable attorney's fees incurred in connection with this litigation, pursuant to 42 U.S.C. 1988 and any other applicable statute or law. And D. Grant her such other relief as the court deems equitable and just. That's it? Oh, yeah. Respectfully submitted,
Yay.
Karen Reed, by her attorneys, Sheehan, Finney, Bass, and Green, Worksman, Jackson, and Quinn.
Okay, I'm not going to show their addresses, but I'm sure you could find it online. So, yeah, you guys, yeah, thank you guys so much for still being here. I see that the number of people watching has really dived down to
Really?
54 people. Yeah. So
It went on
anyway,
and on and on.
no, but this is good though, because I still think what you did is such a great resource to people who, have trouble reading or paying
Right.
attention when it's
Yeah.
not being spoken.
Or people
And
who like podcasts, just listening to
yeah,
stuff. Yeah.
yeah, because for example, when you helped read Charlie's appellate reply brief,
Mm-hmm.
I was even enjoying re-listening to it the next
Oh.
day while I was just driving because, I'm driving, I gotta listen to something. So I really wanted to pay attention to the nuances, the details from this appellate brief, because when I'm just kind of looking at it myself
Yeah.
visually, sometimes my eyes glaze over and it's not really infiltrating my brain
Yeah.
after a while. So I really did appreciate you reading it because
Me
even
and
if
Mona.
people, yeah, even
Yeah.
if people aren't watching live, it can still be a great resource in the
Mm-hmm.
future when people are like, hey, what did that brief, what did it say? What did the court filing say?
Yeah.
So,
Yeah.
yeah. So thank you.
Well,
People are praising you again.
thank you,
Thank
everyone in
you.
the
Great
chat. It was
voice.
my pleasure. Thanks for being here.
Yeah.
Thank you so much.
Now you probably have to
Quiet
be
things,
quiet. You have to be quiet the whole weekend.
right?
Yeah. Yeah, that's right. Yeah, this person says listening is super helpful.
Helpful. I'm ADD. Yeah. Well, that's glad. I'm glad.
Yeah,
That's good.
because people learn
Thank
in
you.
different ways. Yeah.
That's true. They consume things in different ways.
Yeah.
Hi,
Okay, well,
Dawn.
cool. Yeah, hey Dawn, we're
Mhm.
supposed to do a test for audio because Dawn and I are doing a live stream tomorrow.
Okay.
And we're going to talk a little bit about this whole arrest watch of Wendy Adelson,
Mm-hmm.
aka Jill Estrada. So we'll cover that, and then we also want to cover this case that Dawn has been totally deep diving on her channel, which is the Maya Malete, this missing Filipino woman
Yeah.
from Chula Vista who is presumed dead. And they suspect her husband murdered her the same day that she had called a divorce attorney.
Well,
So
that happens.
it's like a typical story where a woman tries to
To
leave,
leave.
and then the husband or boyfriend flips out and kills her.
If they're abusive, they say that's the most dangerous time is when that you try to leave. You have to
Yeah.
be very careful about it and stuff.
Yeah.
Well, that's terrible. I hope they catch him. Have they caught him?
Oh yes, he's already been in court for some preliminary hearings,
Oh, good.
and the
Okay.
trial is coming up eventually, but
But
Dawn
they
knows.
haven't found her body yet or
No,
anything.
it happened, I think, January of 2021. Yeah, quite a while ago.
Wow.
But I mean, it's so obvious that the husband did something to her
Yeah.
because he was lying to her family when they tried to come to the house to see, like, where is she? How come she
Was he
stopped
texting
texting?
them from her phone and stuff?
No, he was doing suspicious stuff, but I'm sure
Mhm.
Dawn knows all the details. But I definitely saw an article where her siblings went to the house
Mhm.
and the husband had locked her bedroom door. And I think he lied to them saying that, oh, she's asleep or something. Yeah, let's not bother
Uh-oh.
her.
So
Yeah.
that's going to be a case where they won't have a body, but they'll still probably be able to get a conviction. There have been a few of those that I've followed. So it's not impossible to do because once you can show that the person stopped all communication, regular communications that they had with everybody, they stopped activity on their bank accounts and et cetera, et cetera. It kind of makes it clear something happened to the person along with the other circumstances that whatever was going on in their life.
Yeah.
So yeah, it's not impossible to get conviction when there's no body.
Mm-hmm.
I
Well,
can
the
think of 2
husband.
cases where it's been done
Hmm.
successfully, yeah.
Yeah, well, in this case, it seems like the husband has behaved in such a shady way. It's like all signs point to the husband.
It sounds like they probably have a really strong case against him.
Yeah, if they're taking it
Mhm.
to trial. So we'll
Yeah.
discuss it tomorrow with Dawn. So please support her
Cool. I'll
channel.
be there. Yeah.
Also, we'll do it live streamed on both channels. So
Yeah, cool.
thank you. Okay, well, I guess we better go. This lasted much longer than I at
2.5 hours,
first
yeah.
thought that it would.
But we did it. We got through it.
You did
So
it. Well, it was mainly you. Like I said, please email me your payment
Oh
account
no.
or Zelle.
Unless you're gonna send me big money, keep it.
Well, okay, or email me your address so I can at least send you something for Christmas. You know,
Aw.
I mean, I don't want to
Well,
be
that's
like a
kind,
taker.
but it's not
Yeah,
necessary.
yeah. So Dawn's channel is her name here that you can see on the screen, Dawn de Quisto. So if you just
Yes.
search
Yeah, I
for
know. I'm
that,
familiar with her in the Dan Martell
yeah,
community.
yeah.
Yeah.
I do have Venmo also, but you guys don't worry about it. I mean, it's a pleasure and a privilege to have YouTube and have the time to do YouTube, sort of. Although I'm
Yeah.
totally ignoring my kids right now. I probably should, because my son has Chinese school tomorrow and we haven't even gone over his homework. So
now
I
you have
better
to do that. Yeah.
yeah. So gotta go. Plus, I have to do this test stream with Dawn to make sure this microphone works okay. But it sounds like it worked. Yeah, it sounds like our microphones were okay today.
Yeah, I can hear
So,
you fine. Yours
okay.
was pretty good for me. I hear it fine.
Yeah. Okay. Well, thank you so much. Have
Thanks,
a good night, everybody.
Have
See
a
you
good
tomorrow.
night.
Take
Or
care.
wherever you are in the world. Everybody over the world.
Have a great Thanksgiving if I don't see you
Yes,
guys
happy
before then.
Thanksgiving.
Thank you. Bye.
Bye.